Leave of your lordship to mention a matter despite repeated memorandums. Matter is not coming over. Double petition of 4178 of 2025. I may pray 2025. The whole matter, in fact, initially 25 initially was filed. May I pray the matter to come out day after tomorrow?
Any urgency, sir?
Pardon, madam?
Any urgency is there?
Very urgent. Madam, more than 41 lakhs rupees of the petition is held up by Bhubaneswar Municipal Corporation without any reason. They are not releasing it. And she is suffering.
That is for admission.
It had come once, and notice was issued, but thereafter none appeared, no.
After notice. But this is after notice matter.
All right.
It will come immediately after notice. Your vacation. After vacation. Holidays.
Well, I will be obliged, my lord will.
No, nothing will happen.
Day after tomorrow only.
With your lordship's permission, my lord.
Immediately after.
My lord, I may pardon, my lord. With your lordship's permission, one recover, leftover one recovery matter, fresh matter, my lord.
Yes.
By day after tomorrow, my lord.
One application for modification of the lordship's order. Yeah, IA number has been inadvertently typed. That is exactly.
IA number to be rectified.
Yes, madam.
Make a chamber rectification. Why it should be posted? Take that.
Because you have to clarify there are two writ application, one another writ application I have advertised here. That is my prayer.
Your application number to be changed, na?
Yes.
Change that chamber order.
I will be permitted to take your lordship.
Appear, my lord, I will clarify if your lordship will.
Immediately after.
I may be pardoned to mention, lordship. This is a read petition for fresh admission. Here, in this matter, some fraudsters have used my name and banner of my school and admitted few students into the institution. Despite of several representation given to the state opposite parties, no action isn't taken.
I have pardon to mention, my lord, the order passed by the National Local Adala. There is a partition suit there. In my branches, there is a compromise decree. As per virtue of the compromise, the National Local Adala passed the order.
Not
Immediately.
Fresh admission urgent necessary malad stay of prayed for malad. But upon malad the petition urgent stay is prayed for by in the writ petition.
Stay of what?
Malad, in fact, malad the petition was dismissed from service after 20 years of malad service malad. And now malad his daughter which is malad going giving examination, and the authority said that you immediately vacate the quarter, malad, so that he could not malad. His daughter could not appear in the examination. That is why there is urgency. Tomorrow, my lord, I pray for only.
My lord, this is pardon. Fresh admission regulation matter. Now the petitioner apprehending their termination as similar situated employee approach this honorable court and this honorable court granted stay tomorrow.
My lord, see fresh admission matter covered under the Saptachandra Parida versus State of Orissa.
Speak clear cut.
My lord, this is a fresh admission matter. It's covered under Saptachandra Parida versus State of Orissa. Hemant Chut.
My lord,
another matter is a transfer matter. Your lordship allowed the memo for today, my lord. That is not listed, my lord.
Not listed.
My lord, this is appointment
matter.
How many memos are there? You should have some opportunity to show your friends also.
This is covered by your identical matters and covered by Loknath Vera case.
After notice matter?
Yes,
after vacation.
Pardon to mention, my lord, it's a matter of change of ownership.
Yes,
wanted to take your lordship cancer patient. I will pray after vacation or just second.
Immediately after vacation.
Pardon to mention, my lord, it's a my lord, is a matter of change of consumer in a water tank, and the opposite party has given a direction to change to obtain the NOC from the co-owners. And it's a matter of urgency, and it's a water tank matter, and the person is using the water tank and not able to use the water tank.
Not able to use. Is it reservoir?
Yes, ma'am.
Reservoir?
No. Overhead water tank, ma'am.
Overhead water tank?
Yes, my lord.
Immediately after vacation, can we take that?
Tomorrow, ma'am.
Yeah.
Pardon to mention, my lord. This is appointment matter, my lord.
Yes, sir.
This is appointment matter, and the petitioner has got more than the cut-off mark, my lord, but she has not been given the appointment. 9718/2024, my lord. Counter and rejector has already been submitted, ma'am.
After vacation. Okay. Yes.
Supplementary list item 1.
Item 1 is a matter of 2001,
Yes.
where he has challenged the construction of a multi-purpose Cyclone center, which was an interim order was passed, status quo of 10/1/2002.
What is the impugned order?
Impugned order is not there. It was only a work order was issued in favor of the petitioner to construct a after super cyclone, my lord. Government has taken a policy that in every coastal areas there will be a multi-purpose purpose cyclone center, where at the time of cyclone some people will take shelter there. And otherwise, throughout the year, the students will read or people will stay there, something like that. Different. That has been stalled here.
That has been stalled.
Yes, because it was
For 25 years it is stalled.
my lord.
Don't tell it to anybody. Don't tell it to anybody. They may laugh at you, at me, at our court. Even in cyclone matters, they are not taking on urgency basis.
My lord, because it was constructed up to 5-6 feet.
You appear for whom?
I'm appearing for the opposite party in the sub-item 2.
Sub-item 2.
Yes, ma'am.
Disaster management.
With OJC 2274 of 2002. They started.
Well, that is what that is what the case is.
That's all.
Yes.
On what ground that was stayed?
My lord, because it was
Which
constructed.
judge stayed? I want to know his name also.
B. Panigrahi. On 10/1/2002.
10/1/2002.
Yes.
10/1/2002. Whether brother Panigrahi was a judge?
No.
Another Panigrahi was.
Another Panigrahi was. Vasudev Panigrahi was there.
Stayed by whom? No, you have challenged. What is that order?
No, we are not challenging. I am for the opposite party there. Petitioner,
Where opposite party there means where?
there means for collector Kendrapara. For the opposite parties, I am there.
Once. Before collector they went.
Yes.
District collector.
District collector.
They went under which section?
My lord, section is, it was a project, my lord. My lord, because the petitioner is absent today.
Let him be absent, no problem.
My lord, that's why I am submitting on state's claim, my lord. Because it was constructed on a Gochor land as he claims.
Gochar lands means Gomal land.
Yes.
Land meant for pasturage.
Yes. Grazing of cattle, my lord.
Grazing of cattle. How many cattle you have?
Your Lordship, I'm for the petitioner in the sub-item 2. And the matter has become infructuous.
Infructuous.
Yes.
Number 1. Number 2, those who got it stayed, how many cattle they have? They may not have any cattle at all, perhaps. Who is your opponent?
One petitioner, my lord, the Rabindranath Swami, as it reveals from here, on the list.
Is he party in person?
Yes. And some more, about 10 petitioners are there.
But how they will know that case is posted today? If they are lawyers, we can understand.
No, they are not law. Their lawyer is there, B.K. Sahu. Their lawyer is there.
Their lawyer is there.
Yes.
He is
B.K.
upset.
Sahu, K.C. Sahu, Mr. H.S. Mishra.
Do you have their phone numbers?
No, in the law.
Call those lawyers. Send somebody to the Bar Association. Let them come. I will not adjourn this matter.
My lord.
Yes. Have they said that they own cattle? Anyway,
No.
They have
They
have not
They
said.
have not said anything.
Well, where is that order of the deputy commissioner?
It was
The one which you have now challenged. Huh?
Is on these things. Right. Not possible.
What is that? The matter may be inquired into by that page another 2. Even annexure 2.
Annexure 2.
Read
That
second
is-
paragraph, unnumbered. The matter may be inquired into by.
It has been alleged that one school come Cyclone.
That is first paragraph I have read.
Yes.
Go to second
The
paragraph.
matter was inquired into by you personally and report within 3 days. Further necessary action at this end. This was a letter to the Tahsildar Mahakalpada.
What the Tahsildar said.
Tahsildar, he has not.
He stepped over the matter because he has nothing to lose.
Yes.
People will die. He will not.
The plan is there. Counter has been filed by opposite party number 3. Let him come, my lord, proceed.
Chief Minister has taken the decision actually.
Yes, 30 lakhs were sanctioned.
Pass over. Send for the lawyers. Please take their phone number, call them, and tell them matter will not be adjourned. Okay? Yes. 1 second. The second matter we can dispose of as having become infectious.
Yes.
WP number. That is OJC. Then which is that?
OJC number 2274 of 2002.
2002, London Council for the OJC means what? Original jurisdictional
Cases.
cases. London Council, whether it is petitioner, what is the status under the rule?
Petitioner.
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 London Council appearing for the petitioner in OJC number 2274 of that I submit that the matter has become infectious and therefore it may be dismissed accordingly.
अपन कौन petitioner पे यहाँ चल रही? हाँ? Drafted. अच्छा.
Ordered and OJC is disposed of. Yeah.
Let's say that on behalf of Mr. Rautre,
On behalf of Mr. Rao.
Shri so appearing on behalf of counsel for the petitioner, the bids. That sounds okay. And such matter should not be stayed. It's all important for the lives of people.
Item number 2.
Yeah.
May I please, Lordship? Under this matter, my lords, was earlier disposed of, my lords, is a government matter. The LIC flat, my lords, which has been allotted in favor of me since 2014, my lords. Thereafter, they issued a notice for e-auction. The lordships have decided on 10th 9, 2025 recently, my lords. I have passed on the judgment, my lords.
What is this IA number 6530?
My lords, why do I have challenged the Annexure 6, my lord, the e-auction notice. I have prayed for stay of the e-auction, my lords, in respect of my residential my lords, the flat which has been allotted to me, 206, my lords, at page annexure, my lords,
I am asking you, what is that IA number 6530?
for interim direction, my lord.
Interim relief.
My lord.
Now you have filed this petition after the disposal of that case.
No, my lords.
Even
It was
before that it was filed.
my lords. It was earlier filed, my lords.
Who appears for the opposite party?
Well, here, I had earlier filed in caveat. This application has been filed in 2025. Those applications your lordship disposed of, those cases are filed earlier, and there was an interim order of stay of it. And here the petitioner has challenged the e-auction notice and asked for stay of the e-auction notice.
Yes,
but
I have set aside the e-auction notices in that judgment.
But your lordships may kindly appreciate there are 5 matters pending before the Honorable Justice Panigrahi. 4 matters have been dismissed, and this matter could not be taken up there. And here his case is that although the letter of cancellation was given in 2014, he slept over. But those petitioners, they filed it, earlier challenged it, and the matter was pending before this Honorable Court. Now, after the e-auction, he along with some other person, they came before this Honorable Court.
E-auction
No.
He said, e-auction has already taken place.
It is he saying.
E-auction has already taken place.
E-auction has taken place.
Yes. But in those cases, there was no auction because there was matters are pending before this Honorable.
E-auction took place when?
In April, exact date, I am not in a position to say. May I request my friend to kindly supply a copy of the writ application so that I can take instruction and.
My lord, e-auction was fixed. My lord,
Give copy.
my lord, I will give.
He is a caveat.
My lord, I will give. My lord, e-auction was fixed, my lords, on 23rd.
You can't argue without serving copy of the
My lord.
on the caveat.
My lord, amen.
Petitioner to serve a copy of the petition along with the application in IA number 6630 of 2025 on the learned counsel appearing for the caveator respondent. First off, post this matter immediately after such service.
Today itself, I am sorry.
I will be allowed.
He has to file objection.
Yes, ma'am.
Call immediately after vacation.
Your lordships may allow me 3 weeks time at least.
Why 3 weeks? To say whether action has taken place or not. Any case on the Bharati case is
Yes, then that I will intimate.
immediately after vacation. Yes.
Item 3.
Interim application is there.
It's there. It will be there only. Caveat is always against interim application, not main matter. Yes. 3. Serial number 3. Yes.
This is a second round litigation matter. I am the assistant teacher in the education institution. Prayer is on page 7. I am challenging direction, watching the order dated 1/8/2024 of the district education officer by the annexure 3.
How long you have been working?
Earlier, my direction was issued to the DO to
No, I
finalize.
am asking you.
I am the assistant teacher, my Hindi teacher in the education institution.
I do not know. I am asking you. How long you have been working?
I am working from first mile annexure 1,
I don't know all that.
1993, annexure 1, page 9, on 15/12/1993.
15/12/93.
93. Then my post was approved by the annexure 2, page 10.
Approved on?
Approved 5/11/2019. This question is there, my lord. Earlier, I filed the writ application before a lawsuit. Direction was issued to the district education officer regarding the regularization of service of certain period, my lord. The DO passed the order by the annexure 3, page 11.
Any representation was given?
No, representation was disposed of and order part in annexure.
This order was
by
passed
rejecting
pursuant to the
Pursuant to representation. Requires consideration. Yes.
one private party, they are annexure OP4 headmaster.
OP4.
The registered post notice which.
Yes. No, the post, I have to direct the post office to open the registration. Yes.
Speed post.
Item 4.
Speed. No.
May I present?
Yes.
In this case, my lord, petitioner have challenged the notice under Annexure 1, 4 for 2025 and 25 for 2025.
Cancellation of lease.
Yes, my lord, of the lease agreement.
On what ground?
The ground stated that I have misutilized that lease premises of 4 decibel that is mentioned in page 14, my lord. They have mentioned that the land has not utilized for the industrial activities. You have misutilized the allotted property for stationary shop and use it as a residential purpose. And status report of unauthorized adjacent IDCO lands, and you have found a constructed SCC roof, the asbestos roof. That is the allegation.
What purpose it was allotted to you?
For industry purpose, my lord.
When it was allotted?
But it was allotted on, my lord, on 19. It was allotted in 28/5/1996, my lord. For 90 years, my lord.
28/5.
28/5/1996, my lord.
1996. What for purpose of industry?
Yes, my lord.
Where have you put
Small
it?
scale industry. Yes, I have established a mixer industry. I have given the photographs, my lord.
Which industry you had said in the list?
Yes, my lord. Pradeep in the Pradeep Industries, my lord.
Huh?
Name and styled as Pradeep.
No, what industry? There's industry after TT.
Small scale industries, my lord. Small scale industries.
Small scale.
Yes, my lord.
What was that?
My lord, small scale industry, that is mixer industries, my lord. Edible mixture industry, my lord.
Small scale industry.
Pradeep Industries for making.
Within 1 year.
Yes, my lord. Yes.
1 year time was given under that. When did you establish?
Yes, my lord. Immediately, my lord.
When it was? Immediately?
Yes, my lord. On that is at Annexure 4, my lord. I got the license from the office bed number 4.
When?
18/5/95, my lord.
18/5/94? How
Yes,
can
my lord.
that be? 28/5/96 is the allotment.
ତା ପୂର୍ବରୁ ମାନେ I have industries. I have allotted this land for that purpose. I have shifted my
That industry to this.
Yes, my lord. And I am operating the same till now. The main grievance is, my lord, that it is a family industries. My family members are working in that industries. They are telling that you are using it as a residential purpose. And I have made the grievance that no, I have.
What is the extent of the plot?
Well, there is 4 decibel that industry situated on 4 decibel of land. 1 room, 2 verandas, and I am making mixtures in that premises.
You are using for both industry and for.
No. Residential use never. But as my family members are working as laborer in that area, they are telling that you are using that premises as residential use.
You are not using.
No. And I have given show cause for that. Yes, madam.
Where is your house? Where do you reside?
My house is 3 kilometers away from the.
Where is that?
Yes, my lord. I have given, my lord, that.
Do you have a.
Yes, my lord.
Voters list?
Yes, my lord. I have given my address is at Angargadia, Isan Nagar. That is under industrial area. That industry is 2 to 3 kilometers away from my residence.
You produce your voters list. Let us see in voters list what you have stated. Do you have a ration card here in your state?
Yes.
You produce a ration card, voter list, Aadhaar card.
Yes, I will produce the Aadhaar card, my lord.
You have produced now? What you have?
Yes, my lord. That's my Aadhaar card, my lord.
Which is that address you have shown?
That Aadhaar is as per the cost title, my lord. That Angargadia, Isan Nagar, industrial area.
Then Aadhaar card means you are residing there.
No, that is my Aadhaar card is my residence address. But the
industrial area.
No, that is not the industrial.
But why have you not made this an annexure?
Well, I have given an address same as cost title address. And my lord, in photograph, my lord, I have also given that Pradeep Industries is a separate part. I have given it page 34, my lord. Name and style, the total photograph of that
You
industry, my lord.
have not brought that edible thing, at least to taste for issue, emergent notice. Consider the petitioner has moved an application in IA number
Well, IA number, this one.
8365 of 2025, supported by an affidavit seeking reprieve against the order of cancellation of the lease in question. First one, counsel for the petitioner submits that his clients do reside in some other place which is reflected in the Aadhaar card. First one. He also submits that the premise on which impugned order of cancellation of the lease is structured is not correct. First one. He has also produced certain photographs which show the what you said, edible
Mixture.
edible mixture edible mixture is being prepared, and that constitutes a small scale industry in the light that constitutes industry in the light of Apex Court decision in BWSSD versus Rajappa, 84 Supreme Court. And therefore, unless the impugned order is stayed, his apple cart would be upset. First, there is prima facie force in this submission. Next part. In the above circumstances, this application having been favored, the cancellation of lease challenged in the petition shall not be given effect to till next date of hearing, and petitioner is permitted to carry on the industrial activity subject to all legal compliances and conditions.
Lordship, issue notice to IDCO.
Yeah, so
Issue notice to IDCO because I am representing only collector wala, so.
correct. Here, so it's we have copy to be acted on. Yeah.
Item 5.
Please, my lord. The petitioner is before my lords against the possible construction by the OP number 4 and 5.
To take stringent action against 4 and 5.
My lord.
Because they are violating the construction bylaws.
My lord.
What they are constructing?
The 5-story building, when I filed the case, fourth floor was going to be casted. Now 5th floor construction is going on. By encroaching my boundary wall as well as the front side of road, and I have made several representation. First, I made a representation to the Cuttack municipality, and in the December 24.
If it is a case of encroachment,
My lord.
you should have to go to civil court.
Here, my lord, by violating the plan which has been approved by the municipality, they have constructed over my boundary. Accordingly, the procedure is I have to make application to the CMC. Now CMC, I have made application.
They have not taken action.
After 2 months, my lord, after several approaches, they asked the opposite plan 4 and 5 to stop construction. It is available to my lords at page 18. Thereafter, without following the same, again they are proceeding with the construction. I made application to the municipality what action you have taken. Now they have intimated my file is not traceable, my lord, and he is going to.
They have put it in the 5th floor.
Yes, my lord. Your lordship, I am bringing my lord's kind notice on page 24.
Issue. You take emergent notice.
My lord.
Issue emergent notice. AG is party.
Yes.
One. They are not parties. 1,
4 and 5.
notice to 1, 2, 3. Correct?
My lord.
First off. All respondents. All respondents.
My lord.
Okay. post immediately after service.
Item 6.
Till then, what can be done? Can we halt the construction? Rains are lashing. What will happen? If you succeed, building will be pulled down. Don't worry. You have seen that Subrato Rai, which is that judge, famous judge.
Here, what has happened? At least municipality should take action immediately.
Let us.
Item 6.
Your Lordship may fix a start.
How can it? Now let notice move. Post it immediately.
Yes, ma'am.
May I please, my lords?
Yeah.
Matter of regulation of Ganasika, my lord, a claim has been rejected. The Annex 3, page 27, my
How
lord.
long you have served?
17 years, my lord.
27 years. Issue emergent notice. Then the requested to accept notice for the respondent. All respondents.
Yes, my lord.
Yes. Next.
Item 7.
My lord, may I please, my lord? My
You are
lord,
not in representation for regularization.
No. Rejection order, my complaint.
It is not revealed that. Yes.
my lord, I have challenged impunct order at Annex 01 series, my lord, as page 16, my lord. On 4 grounds, I have challenged it, my lord. My lord.
The BO directed release of the salary.
My lord, I have been victimized in my ULS, my lord, on unutilized leave salary. They have reduced my leave salary up to 150 days, my lord. This is the order, my lord. This has been passed by a district education officer who is not competent to pass this order, my lord. BO is the disciplinary authority and DO has passed this order. So on the ground of competency, it is liable to be quashed, my lord. As second ground, my lord.
He requested to accept notice for the office.
All right, my lord.
Item 8.
My lord, here in the petition of Miller,
Yes.
with the dealer Miller to explosive substantial materials Miller. Here I am challenging the gazette notification under Annex 1, page 18. And consequence letter that notice dated 28/7/2025, page 49, Annex 14 Miller.
This gazette notification is what?
Gazette notification for prohibit import, possession and transport. Explosive.
It's under the Explosives Act.
Under the Explosive Act. I am done that. And here, my lord, they exempted the oil corporation company till 30 September 2025. But so far as the petitioners are concerned, now we have a huge stock that is near about 30 to 40 crores. If that will be destructed by the department, then we will be suffering from that.
So before 30, you will remove everything.
Yes. Now, what happened, Miller? Now 38, now 7 days. That is not possible. That notification 1/7/2025. On similar matters, coordinate bank already issued notice to the Union of India, Miller. This order. Lordship may issue notice and take this matter in this case, Miller. What happened? Final order.
No, you said up to 39 they have given to others.
To oil company.
All. On that ground, you are seeking parity.
Yes, parity. Parity means we need 3 months time.
But 30 September is given to the oil companies only.
30th 9 oil company till 1/7/2025 to 30th 9 2025.
That is 2 months.
32 months. Now we are only 7 days.
You were given notice on which day?
28/7/2025.
How many months now?
My lord?
How many months? More than 2 months are over.
Now they are not allowed. Now they are not allowed to supply. They are not allowed. They are, after proceedings is the page 49.
Any interim order is granted by the other court?
No.
Issue emergent notice. Call this matter along with
25146 of 2025.
All right.
All cases are same.
You appear for OPs?
1 to 4.
Which OP?
1 to 4, madam.
1 to 4. All right.
Many cases are being filed. Let them give all the list, my
What do
lord.
you say? If you do not give them a reasonable time, what they should do? You give reasonable time and everything will be over. We can dispose of that matter only.
Well, also may dispose of. If you are too much time, that is sufficient.
1 month time will give you.
1 month is not possible.
My lord,
because
we'll take instruction,
huge
let me give it to-
different district, my lord.
May I audible,
Too
my
much
lord?
time is required, my lord. Proximate is
May I
page
audible,
18,
my lord?
it's very clear.
Just consult your officer and come back at
My learned senior DSGI sir
My
is
lord, may I
appeared.
audible, my lord?
Yes.
My lord, let me give some time because
Yes,
you acted on the special statute. I will take instruction from the department. Let me get after tomorrow also. No issue.
All day after tomorrow.
Yes, ma'am.
ESG appears for zones. Yes. ESG assisted by signed association. If the matter is involved, matter involves a matter lies in a very short and narrow compass. Call this matter day after. Okay.
Item
What
9.
is there? All the
Let's say fix it 25th. 25th is fine. 25th.
25th.
Thursday. 25th. Thursday.
All Thursday.
In fresh admission, lord.
Huh?
In fresh admission.
Don't worry, everything will listen here.
Hey, but he will tell, give you time. He will instruct his friend to give time to you. You are seeking 2 months time.
Yes.
Let us, they will be in a position to know how much time you need. I did not
Yes, sir.
have explosive industry at any point of time.
Yes.
I was only a lawyer.
I am praying, my lord, list this matter on and get a heading of fresh admission.
Let us see. Let us. Yes.
Item number 9.
Please, your lordship, on behalf of Mr. Government of National, Lord, here the demonstrator claiming the EDC developed, my lord. Your lordship already.
Similar matters we have.
My lord.
Wait, what order we have passed? Have we changed the dates and other things?
With
You that?
there is an 17 and finally for the open number 2, my lord.
His name to be. Just ask him to change their names. Dates and other things you have to change. na?
चेंज कर दिया डेट उड़ा के सब
हाँ.
डेट नंबर फंबर जहाँ की सब चेंज करके दे
This board. Yes.
Item 10.
My lord, petitioner pays for a direction to the opposite party or antedating promotion, my lord. Similar order already
Other
been
matters we have posted on which day?
No, my lord, disposal of the
Only. So consider representation.
my lord, taking into and similar.
Change the dates.
Yes, ma'am.
Then advise your friend also to change dates and other things.
Yes.
Okay.
Similar benefit already been given under Annexure 4 series, my lord. And also in the meantime, the Supreme Court already been.
Dismiss, SLP
Yes, yes.
dismissed also.
Yes, my lord. And 6, my lord.
लर्न बाय in between लर्न
So
बाय
G's name. Yes.
Nearest cadre to senior.
Whatever.
most पुराना
Item 11.
May I please, Your Lord? Here I am challenging the action of the university, which is in violation of the law laid down by the Honorable Apex Court in Parasing and Horguru Pratap Singh.
What university has done to you?
My Lord, I was a notice was issued after selection process. I was appointed under the university on contractual basis. Well, it was being renewed from time to time. Well, without any notice, well, my service under the university has been terminated, and it has been now it has been made as under the outsourcing agency.
But it happened in 3 months ago.
No, I have not joined till now.
Huh?
I have not, without giving any notice. So I have not joined till now. So that's why I have prayed in the miss case to allow me to join under the university.
Now that order was made on which 13/6/25.
Yes.
But more than 3 months are over now.
No, I have not joined till now. And the post is still lying vacant.
You take emergent notice. We will let us see after service up to issue emergent notice. You appear for
I am appearing for opposite parties 1 to 4 on behalf of Union of India.
Shri. Join. So appears for 1 to 4.
No, 1 to 4 means he will appear for the university.
Yes, they are appearing
1 to 4. The Central Sanskrit University. But it,
5 is also another wing of the university.
yeah, 5 also have to.
instructions will also only.
No, how can you say? It's a director Central Sanskrit University.
Campus is only different.
Ah,
Yes, I will take instructions.
yeah,
on that.
all right. Issue emergent notice to 5. Learned AGA, Mr. G, accept notice for 6. No, separate notice. 5 and 6, emergent notice. Oh.
So far as IA is concerned,
Let us see.
the post shall not be filled up in the meantime because they will fill up the post through any other person.
The appointment, if any, shall be subject to outcome of the petition. IAG this thing.
Item 12.
May I please, Your Lordship?
Yes.
Petitioner has filed this current writ application to challenge the actions of the opposite party number 2 towards not filling the vacant post in pursuant to the advertisement dated 8/1/2024. Malad,
8/1/24 is
advertisement was issued.
why you are not, Mr. G, why are you not appointing people? The people do not have employment. Every day a newspaper I read.
Yes,
You have advertised and you don't want to fill up. What is the reason?
maybe I.
You have a lot of money to do all kinds of functions and other things you are entitled.
No, my
But
lord.
what about the
it
employment?
is- I do not know whether any interim order is continuing or not.
As far as my instruction, my lords, there is no interim order which
Have you
is.
given any representation saying pursuant to this you make appointment?
Yes, my lord.
Where is that?
Annexation number 6.
Is that number?
6, my lords. Page 42 and 43.
21 February 25.
Yes.
They request you to recruit me as soon as this. Consider at least this representation.
Yes.
Sorry. The short grievance of the petitioner is as to non-consideration of his representation dated 21 February 25. Wherein he has sought for his appointment in terms of advertisement dated 8/1/2024. Advertisement number 1 of 2024 dated 8/1/2024. First off, he also the representation, which is short and sweet, reads as under. Next paragraph. Learned counsel for the petitioner submits that the advertisement for calling the candidate for appointment is issued only because there is requirement of workforce in the government, and therefore once such advertisement is issued, it has to meet its logical conclusion. First off, he also tells that many people would become ace barred if periodical appointments, recruitment are not undertaken. First off. Next paragraph. Learned AGA appearing for the OPs very fairly submits that he would instruct OP number.
Opposite party number 2, my lords.
OP number 2 to look into the grievance of the petitioner as has been aired in the subject representation on a war footing. Good. If all contentions are kept open. First off, with this proposition, counsel for the petitioner is agreeable. First, next, in the above circumstances, it means orphan to solicit. Now, no course. Yes.
Item 13.
Grateful, my lords.
Yeah.
Next. This reader placement matter is covered by the judgment passed in Lokanath Behra case.
They have changed the date.
Yes, I have changed.
Please put on.
Actually,
University is a party. No, university is not a party.
No,
It is party. Give copy to Mr. G also. Party is reference, na?
copy
Yes.
to the. No. Take it.
I will receive the copy of the order. Give that. Please put on. Next.
Item 14.
Already issue notice, man.
Notice to be issued in these cases.
Come along with me.
What's the long name? I give you the numbers.
My lord.
30. Yes. 15.
Item 15.
Yes, Mr.
Grant of pension, my lord. That petition. My lord.
This
That's
is added employees.
Petitioner.
Added employees pen. That's Hemant Chotrai's case.
Lordship should try.
Yes.
Give the representation.
no, my lord. That the covered by that judgment, my lord.
Or by judgment.
But that is pending for adjudication.
Yes, my lord.
In the
Read a bit.
Read a bit.
Read a bit.
Yes.
Read a bit.
But we will dispose of this matter, it will be subject to outcome of
that writ appeal, yes.
But petitioner has structured the prayer as under. First one. Learned counsel for the petitioner vehemently submit that in the coordinate bench of this court, in WPC 17067 of 2023 between Hemanta Kumar Chaudhary versus State of Odisha has granted relief of the kind to the other similarly circumstanced litigants, and therefore the same needs to be extended to his client as well. First, next one. Learned counsel AGA, Mr. G appearing for the OPs, very fairly submits that the Hemant Sumra is being examined by the coordinated by the division bench of this court. Do you have writ appeal number?
No,
197 by 2024.
In writ appeal number 197 of 2024, and therefore decision at the hands of the division bench may be awaited. First. However, learned counsel for the petitioner submits that this case may be disposed of subject to outcome of the division bench decision. Division bench decisions. First one, there is a sense of reason and justice in this submission, and therefore the same is accepted. First one. Next paragraph. In the above circumstances, this petition is disposed of according the same benefit as has been accorded to Hemanta Kumar in the Hemanta Kumar Chaudhary Supra, subject to outcome of the rate appeal mentioned above. First, no course.
Item 16.
Yeah.
May I plead yours?
Yes.
Challenging the order of opposite party number 1 and 2 on the ground of allegation of multiple allotment.
They have directed cancellation of allotment now.
Cancellation of the plot, wherein the first plot is not covered under the Bhubaneswar Municipal Corporation. And the
This I had given on judgment.
Yes, my lord.
Matter, no? Which is that matter?
My lord, that is Susama Misra versus State of Odisha.
Do you have a WP number?
WPC number 8344 of 2022.
Issue emergent notice. Who are the parties?
Bhubaneswar Development Authorities, my lord.
Go to first section. Emergent notice to 1 and 2. First one. An application is moved in IN number so and so, seeking retreat. First one. The net counsel for the petitioner submits that this court in a similar matter, that is in WP number so and so between Seniority Mishra versus so and so has granted full relief to the litigant, and therefore the reprieve may be granted at this stage. First, there is force in this submission. Will give that judgment name, WP number, name, disposed of. Date. There is force in this submission. Next paragraph. In the above circumstances, no forcive action shall be taken pursuant to impugned order dated 29/7/2025. That's the next
9 Miller. 9 Miller.
9 till the next date of web call. There also. Next.
Item 17.
Yes, brother. Dismissal from service.
I may pardon your lordship. I mean, visit your lordship. I pray your lordship kindly taken after vacancy, your lordship. I have some personal difficulties, your lordship.
Do you have objection for issuing notice?
No, your lordship kindly, your lordship grateful. Issue notice.
No. here for all peace, all of it. Next.
Item
Your
18.
Lordship, may I pray, Your Lordship, that there is a IA, Your Lordship.
I will be considered not now. Yes, you are already 3 years now.
Great.
Item 18.
Yeah.
Here, this petition frames for a direction to the opposite party to regularize the service of the petition from the date of our initial appointment.
That is 25/1/2019.
Yes, my lord. Government has taken a decision to regularize the service of similarly placed person from their initial date of appointments, superseding the earlier regularization order. Earlier, they have regularized, government has regularized the service of the contract teachers by Annex 2 million. That has been a challenge before the Honorable Tribunal, and Honorable Tribunal has allowed that application. On that basis, government has taken a decision to implement that order. Annex 4, 25/1.
Need to make representation.
Yes, my lord.
Where is that?
That is the Annex 10 million.
That's the
All other,
decided.
my lord,
Not yet decided on that.
not yet decided. All other district education officer has implemented that.
Yes, in the which that judgment? Justice Sarangi, Honorable Justice Sarangi's judgment.
No, my lord, that is fast disposed of after implementation of the order of the tribunal. State has prepared the
And after the Supreme Court, it failed. No,
before filing the writ application, they went to Supreme Court. That has been dismissed, giving liberty to approach this court. And this honorable court has dismissed the writ application. And private person has also challenged that order. That has also been dismissed.
challenging the order of the tribunal.
Yes, my lord.
You consider representation, brother. The short grievance of the petitioner means as to non-consideration of his representation dated, his or her representation dated 1/6/2025, a copy whereof awaits at Annex 10, wherein she has sought for regularization of her service with effect from
1/1/89.
1/1/1989 in the light of various circulars and the decisions cited therein. First one, Turner counsel for the petitioner submits that even in the light of government policy decisions evolved pursuant to state administrative tribunal's decision in OA number 3187 of 2009.
1735. 1735.
They have written 3187.
Annex 4 million. 1735 C of 2004 million.
1735
C.
million of 2004
million.
What you written now? Last line. And that no decision is taken thereon, which is unjust and arbitrary. First, which inaction is unjust and arbitrary. First, they also quote Article 350 of the Constitution of India in support of its contention, as has been interpreted by various high courts in the country. First, next one. Learned AAC appearing for the OP submits that he would instruct OP number
3 million.
3 to look into the grievance of the petitioner as has been heard in the subject representation if all contentions are kept open. First, the counsel for the petitioner is agreeable to this proposition. Next one, in above circumstances, petition is disposed of 8 weeks. Open to submission. Next.
Item 19.
19 months the Roping Masi case, also already issued notice and stay the recovery also.
Issue emergent notice. The application in 15193 of 2025, supported by an affidavit is moved, seeking relief in the light of a fixed quotation in Rafiq Masi, 2014-15 Supreme Court.
15 man. 9696.
First of
Item 26.
in similar matters, this court has already granted reprieve to the similar circumstance litigants, argues counsel for the petitioner. First of all,
Your Lordship, we should notice and stay the recovery set.
in view of the above, issue emergent notice and interim order of stay
6 and 7.
Recovery.
6 and 7 man.
pursuant to annexures
6 and 7 man.
6 and 7 till next date of hearing. The ASC accepts notice for all this. Next. Call along with WP number. Just look.
Item 20.
Mr. Your Lord.
Yeah.
Here, my Lord.
Yeah.
The prayer in page 11 that I am continuing as the administrating charge. My prayer is regarding the modification of the provisional gradation list published by the DEO, my Lord. That in the, Your Lordship, turn to page 19. This is a letter and gradation list issued by the DEO to the school. In that letter, page 19, after verification, you are to report the correction, omission, or addition, if any, in the gradation list. The compliance report to the extent may reach to the question. According to that one, I objected. I submitted the application.
Where is your name?
My name is, you will turn to page 20. My name is serial number 9, Gadadhar Panigirai. But my junior is serial number 8, Niranjan Sahu. This is my objection, my lord. So I submitted the objection before the DO, that page. And the managing committee also submitted the resolution before that. I am the senior. So my application is page 27.
Thereafter, what happened?
Thereafter, my lord, then I came before your lordship. This honorable court passed the order by then you also turn to page 32, 33, saying that you file the application before the appropriate authority. So by the annexure 12, page 34, I submitted representation before the director secondary education. It is pending. By speed post, I followed according to that order of this honorable court. It is pending, and I am my prayer is for to modify the provisional list passed by the DO, my lord.
But that modifying provisional list. Finalize the provisional,
no, that
list, this rectification.
That provisional list forwarded to the director for final version list. And I, as per the letter of the DO, I submitted the application before the DO to modify. Consider.
But that can be considered.
So thereafter I came before your lordship. This honorable court passed the order that you file the application before the appropriate
authority. You have filed it now.
So I filed the application before the director. It is pending, my lord.
We'll direct the director to take into this representation into consideration and then finalize the list. All right.
Yes.
That can be done. Yes. The law. Which is that? Kathe Gowda versus Swine State of Karnataka. Right now. The short grievance of the petitioner is as to his placement in the gradation list below his junior. First one. Petitioner had approached this court earlier in WPC 2932 of 2025, hearing the grievance. First one. The coordinate bench of this court-wide order dated 24/2. Where is that?
33, page 33.
Page 33.
No, you have withdrawn the petition.
Yes, liberty to approach.
Liberty to approach.
Wide order dated 24/2/2025 permitted withdrawal of the petition, reserving liberty to the petitioner to approach appropriate authority. First one. Counsel submits that in terms of that, the client has already made a representation dated 2/4/2025 to
Before
the
the
Director Secondary Education, Odisha Bhuneshwar, at an exit 12, pointing out that he ought to have been placed in the gradation list above his junior. First of all, counsel complains that till date nothing has been done in the matter, and that in all probability the representation shall not meet its fate. First, next paragraph. Learned AGA appearing for the OP submits that it is only the provisional gradation list against which the petitioner is now grieving before the court, and that is not permissible, since the cause of action would become cohort only after final gradation list with the mistake is prepared and published. First one. Having so contended, now he agrees with the suggestion of this court that the second OP number to instruct OP number 2 to look into the grievance of the petitioner as has been held in the subject representation in accordance with law.
May I say?
Yeah.
He has also implicated the opposite party number.
That makes sense because provisional seniority.
Giving opportunity for both.
That right. Just agrees with the suggestion of this court that he would instruct OP number 2 to look into the grievance of the petitioner as has been held in the subject representation in accordance with law, and after giving opportunity of hearing to other stakeholders too. First of all, this is absolutely correct. First of all, next paragraph. In the above circumstances, petition is the code of 8 things. First of all, the OP numbers, private.
4 and 5. Managing committee and 5.
Yeah, it hardly needs to be stated that an opportunity of hearing should be given to OP numbers 4 and 5, to whom notice has not been ordered by this court since no effective order is being passed. First one. Registry to send a copy of this order to OP numbers 4 and 5 by speed post immediately. Okay.
I think I is there, one I is there. Why is 14514 My prayer miller that if the final gradation not published, so till disposal of the dependent, that may be kept in evidence.
IAPL in main matter itself.
Object to
next.
May I please,
Yeah.
The petitioner's wife expired in the year 2016.
Wife expired
In the year 2016. 2016.
Can you give the date?
Annexure 2.
I do not know.
No, I'm just. That is on 14th May 2016.
Yeah.
After almost 7 years, she was noticed by the BDA, Bhubaneswar Development Authority, opposite party number 3, for multiple allotment of plots.
I think similar to item 16 you lordship just now.
Now, this is a little peculiar case, your lordship. Now the plot which has been mentioned in their show cause as a multiple allotment of plot was never allotted to her.
Was not allotted.
Not allotted to her. I filed my show cause reply saying that it was never allotted to my late wife. And furthermore, now the plot where I am living, it was bought on post-possession basis, on resale basis from somebody, after getting the approval from the authorities. So this plot, what you have said as multiple allotment, was never allotted to my late wife. Please provide me with the documents.
By which you were allotted.
Yes, that plot, particular plot.
That they did not give.
Did not.
Now in this order.
Yes. Now, your lordship, what have they done? Now they have cancelled my plot, where is my residential plot, where I am living with my children. Now they have cancelled it and have given me the notice to vacate the said plot, annexure 6, your lordship.
Therefore, your learned Mr. Lenka said it is similar to 16.
Yes. Now they have given, so I...
Do you have objection if I pass interim protection order?
Great.
Kindly see.
Great.
Issue emergent notice. Learned EG accepts notice for
1 and 2.
1 and 2. How many states of Odisha are here in your state?
Sir,
How many states of Orissa are here in your province? Kindly come to cost statement.
One is state of Orissa represented by Secretary Housing and
Another is state of Orissa. How many states of Orissa?
Principal Secretary.
Housing.
Only one.
Issue emergent notice. Learned AG accepts notice for 1 and 2. First one. Emergent notice to the rest of the respondents. Respondent. Next correction. Learned counsel appearing for the petitioner points out IA number 1 application in IA number 15285 of 2025 supported by an affidavit contending that at any time his claims may be removed from the concerned structure in question, which is built on the site, subject site. First, he also tells the court that at no point of time the deceased spouse of his client was allotted any site, and therefore the impugned order is absolutely unsustainable. First, a prima facie case is made for the issuance of interim protection. First, he also tells that in similar matters, reprieve has been granted to similarly circumstanced litigants. First, next one, in the above circumstances, application having been favored, the OP numbers
4, 3, 4.
3 to 6 are directed not to disturb, not to give effect to the impugned order at Annexure 6. Annexure 6 till next date of hearing. First, web copy to be acted. Next.
Item 22.
Gratefully. My application for mutual transfer has been rejected. That is under Annexure 4. And the reason of rejection is, Your Lordship can kindly turn to Annexure 5. The government notification dated 14/5/2025. Your Lordship may, well, I am a state cadre employee. Your Lordship may kindly come to page 26.
Mutual transfer is allowed after 6 years.
No. For mutual transfer, there is no restriction.
No clause.
Yes. Page 26, Your Lordship may kindly see clause 2L.
2L.
Yes.
The
inter-district transfer can be availed by an employee only once in his/her total service period. Any person who has already availed inter-district transfer earlier will not be considered for any such transfer again. The DO of the district shall be responsible for making this check using service book and other related documents of teachers while validating the transfer applications online. I applied for inter-district transfer.
At any time, did you avail that benefit?
My lord, yes, once I have availed. My lord, that restriction is not applicable for state cadre employees in view of, because, my lord, so far as state cadre employees are concerned, they are guided by a statutory rule. Their service condition is guided by 1993 rules. And here also they have mentioned, Your Lordship may kindly see clause 3, inter-district transfer. The ground of transfer and employees transferable under different grounds. The employees of different category may be transferred from one district to another on the grounds mentioned against each in the following table. Your Lordship may kindly look at the table at page 27. Yes, serial number 1. My lord, my case comes under serial number 1. Senior SCS headmaster and TG teachers, they belong to state cadre.
As mentioned in
2D is applicable, not L. Not L. L is applicable for district cadre teachers.
GKL.
GKL.
Take notice.
Yes.
Requested to accept notice from the office. Call immediately after vacation. Yes.
Item 23.
Item 23, this is covered by Lokunath Behra. I have corrected the.
The dates in particular?
Yes, I have already corrected. All the cases, sir.
Please go down. Yes, next.
Item 24.
The petitioner is a retired teacher and prayed for release of pension with financial benefits along with area salaries as per Annexure 1 and 2. Annexure 2 is clearly, but the authority has recommended the pension of the petitioner to the OP number 5. OP number 5 is a control of accounts.
What he says?
He has written a letter to the BO and BO has written a letter, the Annexure 3 to 6, all are the same, but I'm not getting the pension.
Only exchange of letter.
Yes.
Yes, sir, you take notice. This is a case where heavy cost will be imposed. Kindly see the information which he has sought for from the block education officer.
Yes.
Why block education officer is not giving information?
I'll take it.
Issue emergent notice. Learned DGM Lanka accepts notice for OP numbers 1 to 4. Emergent notice to 5. Who is that standing counsel appearing for controller? Controller of accounts.
Controller state.
State only?
Yes.
Controller of accounts is state?
State.
Yes.
Okay, all OPs. Call this matter after vacation. In the meanwhile, it is open to the OPs to file objections. Objection. Matter appears to be involving a serious lapse on some OPs. Which aspect would
4, 5.
OP numbers 4 and 5. Which aspect would be addressed on the next date of hearing? Yes.
Your Lordship has fixed to.
No, I can't fix it. It will come immediately.
Item 25.
Because I am saying that it is a pension matter.
Correct. No, it will come. Emergent notice I have ordered. Yes.
Item 25. May I please, Your Lordship? Petitioner is presently serving as a Hindi teacher on deputation basis, has filed this writ petition seeking his transfer to the said school in accordance with the Government of Odisha notification dated 14/5/2025 under Annexure 4. Accordingly, he has made a representation under Annexure 6 before the opposite party number 4, that is but till date, no action has been taken on that representation.
Petitioner, a teacher,
My lord, Hindi teacher.
a Hindi teacher, has made a representation dated 25/6/2025 to the district education officer Kendrapara at Annexure 6, seeking her transfer to any vacant post of Hindi teacher in
Vacant for Punjab Government High School.
High school.
Punjab Government High School.
In any government high school. In a panchayat government, in any panchayat government high school. Where?
Punjab.
Marshagai.
No, sir.
Angulai, Marshagai. Come on, Angulai. Just look.
Where he has been deputed.
Just look into this and they're all last paragraph. Okay? Right there. Counsel for the petitioner draws attention of the court to the government policy transfer guidelines dated 14/5/2025 and submits that the subject representation ought to have been considered in a reasonable time. This having not been done, according to him, there is lapse attributable to the officials and therefore this vote should come to the aid of its court. Next paragraph. Learned AGA Mr. Lenka appearing for the OPs, having resisted the petition, now fairly agrees with the suggestion of this court to instruct district education officer OP number 4 to look into the grievance of the petitioner in a time-bound way and in accordance with law. First, he puts a caveat that all contention should be kept open. with which the net counsel for the petitioner is agreed. Next purpose, the above circumstances which needs to be followed up 6 weeks.
Obliged.
Like 19.
Item 27.
But the petitioner is a selected candidate for the post of postgraduate teacher, and already verification of document has already been completed, and then counseling already completed.
Appointment orders are not issued.
When the orientation program was started, he appeared, and the Nijuti Patra already issued to all. But except the petitioner on the ground that he is a sports person, so sports certificate, authenticity of sports certificate has been asked for to the wide annexure 6 , and that is outed. Annexure 6 pays 37 .
What they say?
Well, already they have, after verification of document, they have found certificates is true, and only the sports certificate is concerned. They have sent to the Secretary General Hon'Ble Association India, Lucknow, for verification of certificates by the annexure 1 for authenticity. But that has not, the authenticity of the report has not been obtained. So I think the report they have not issued the appointment order, but they have already issued the appointment order to all candidates.
Post certificate for issue of identity card. The authentication certificate is necessary.
Of Myler. They have already issued by the annexure 6 , the letter has already been issued to them to give a report.
They are not giving that.
They have not issued.
So you should go and do something there. They will do it.
But it is not possible.
Yes, you ask him to look into the certificates, and if they are genuine, immediately he has to send that by post.
We have written on March 25, page annexure 6.
More than 6 months are over now.
Yes.
He wants something else.
We will pursue the matter.
No, that will be no use. Otherwise, all such people will come to court. Perhaps he needs something.
Because
you tell him, court will pay him.
Because the authentication is necessary.
Correct.
And we have requested the Secretary General Hon'Ble Association of India to authenticate, and the matter is pending with them.
What is the nature of that authority? Is it your client? No.
No.
Not your client.
No. That is a private association.
Private association. But they have issued that certificate.
Yes.
Therefore, you wanted to ascertain what is the
correctness of that.
You take what he should do. Some other officer has to do that. Who is not in his control.
Emergency notice.
Issue emergency notice. Then he requested to accept notice for OP numbers 1, 2, 3, and 4. Emergency notice 2. Or will direct OP number 5 to consider the expeditious examination of the certificates and send the report.
That can the direction be issued to private organization or that? That's
correct. But if state requires something from the private authority, then his action partakes the character of public authority.
May I suggest let notice go. Let notice go. If they do it on the
OP number 5. Post immediately after service, since matter lies in a narrow compass. Yeah.
Well, one post
Petitioner has filed application in I number 15542 of 2025, supported by an affidavit seeking an interim direction to reserve one post for his client. First answer. There appears to be force in the submission of the net counsel for the petitioner that petitioner has got fair chances of success in this litigation. And if no post is kept what kind of comma, it may create some difficulty. First off. Next one. In the above circumstances, OP numbers 1 to 1. Which OP?
मतलब OP number मिलट 1 मिलट.
OP number
1 and 3
1
मिलट.
and 3 are directed. 1 and 4, no? 1 and 3 and 4.
1 and 2 मिलट.
Not 2. Who is the appointing authority?
Appointing authority मिलट 1 मिलट.
1 and 2 are directed to keep one post vacant under the sports quota. Till next date of his. Yes.
Item 28.
May I please?
Yes. This is.
Apologies.
Are you angry on the book?
I just slipped down. Your Lordships, I am praying for equal pay for equal work by challenging the Annexure 2, Your Lordships, the resolution which has been passed by.
In fact, Dipti Roy and Vijay Ketan Khatua.
Yes, Your Lordships. They cover the same thing, same matter. The resolution.
File any representation.
I have not annexed those, but I have filed those representations, Your Lordship.
You have filed representation.
Yes.
Can we dispose of yes.
I will permit you to file representation. You file a representation within 10 days, and I will direct them to consider it within 8 weeks in the light of these two decisions.
Yes.
As Your Lordship.
All right. Do you agree with this proposal?
Yes, Your Lordships.
Right now.
Both the items are of the same right, Your Lordships.
Both these are same.
Yes.
Do you have a copy of the representation?
I have not annexed those, but I don't have it right now.
Pass it on. You don't have?
No, I don't have it right now.
Identical prayer.
Yes, Your Lordship.
The short grievance of the petitioners is as to non-consideration of the request for revision of scales of pay for that are admissible to the regular state government employees by resolution number 26342/F dated 7/9/2017. Right, 19. In the light of decisions of this court in which is that judgment?
Your Lordships, one is WPC number 5022 of 2013, that is Ritanjali.
Slowly, she has to write down now.
Yes. WPC number.
Of a coordinate bench decision in Srimati Dipti Roy versus State of Orissa, 2004, 2 ALR 718, and Vijay Ketan Khatua versus State of Orissa, 2015, 2 ALR 452. First up, Learned Counsel for the petitioner submits that even when her clients are entitled to the benefit, nothing has been done in the matter despite repeated requests. First, next paragraph. Learned AGA Mr. Lenka submits that no representation as such is disclosed in the petition, nor any copy thereof is produced by the petitioner, and therefore, ordinarily, the writ of mandamus cannot be granted. First one, having so contended, he standing tall at the bar submits that if the petitioners make appropriate representations, there would be no difficulty for his official clients to look into the same in accordance with law if all contentions are kept open. First one, counsel for the petitioners accordance with this submission. First, next paragraph. In the above circumstances, petitions are disposed of, preserving liberty to the petitioners to make appropriate representation with supporting material within a period of 2 weeks. And if one is made, the same shall be considered by OP number 2. OP number 2.
No, OP number 3, madam. Director has it.
OP number 3.
Yes.
OP number 3.
The lecturer.
OP numbers 2 and 3.
The 2 is school and mass education because they are lecturer.
OP
They
number
wrongly says employees.
3. Within an outer limit of 8 weeks. Yes, please. And inform result of such consultation to the petitioner. Individual, personal, all contentions are kept open. Next paragraph. It is open to P number 3 to solicit any information, etc., etc., etc. Yes. This follow. Now no course.
Item 29.
Obliged.
Item 29 now. Yeah.
This is a promotion matter. The petitioner is a regular primary school teacher. Kindly have a class annex on 19 minor. After filing one WPC and two contempt petition, the opposite parties have agreed, my lord, to promote me. After getting promotion, after getting permission, obtaining necessary orders from the Honorable High Court. No time is mentioned. My junior staffs have been already promoted. And
they have given representation.
My lord.
2012, 2022. 2012, 2022.
Annexure 6, page 50.
For promotion. They have given promotion to your junior.
My lord.
Where are they?
Page 12, my lord.
Why you are not given?
Page 13, my lord.
Why you are not given?
My lord, the petitioner was suspended when he was on medical leave, my lord. After the leave was sanctioned by the competent authority. Then he prepared before the administrative tribunal para, my lord, 5.
What happened?
Annexure 1. Again he reinstated, my lord.
Whether your proceedings against you were questioned.
My lord.
Where is that order?
Annexure 1, my lord.
Annexure 1.
My lord. My lord. Sorry, my lord.
No, suspension.
No, my lord. Suspension.
Where is the order of tribunal? Did he go to tribunal?
My lord. OL number, my lord. 2842 of 2018.
2842 of 2018.
Para 5, my lord, I mentioned in para 5.
What happened to that matter?
It was quashed, my lord.
Quashed? But you have not produced that copy. Do you have a copy of that with you? It's the important document, no?
My lord.
Do you have a copy in your file?
Page 13, your lordship, you can see. Page 13.
1-3.
Yes. The order giving promotion to his junior, as he claimed, without prejudice to the claims of others and portions of Orissa Elementary Education so-and-so, rules, subsequent amendment rules so-and-so instruction, then of the Orissa District Education, the following level 5B, senior teacher is hereby provisionally promoted to the post of level 4 graduate teacher in the arts upper primary school in the state level at so and posted to the school as noted against him, public harm. The promotion is purely temporary and subject to outcome of different OS and WPC pending for adjudication. The promotion shall be effective from the date of he or she joins in the promotional post. This is the opposite party number 5, to whom he says that his junior has been promoted.
Yes.
This is the position as per the 13th.
Yes, you have given a promotion to the junior.
Junior, because the OA and...
No, he says OA is allowed.
But there is no such...
The order of the director, my lord, has admitted that the OA is in our favor.
Why you did not produce them?
In April 25, a communication is made to the petitioner that the case is pending which annex page 19, which referring to the subject, I am to inform that promotion process of elementary teachers is under sub judice of Hon'Ble High Court.
Brother, there is that order of the tribunal. You produce that copy. Petitioner to produce a copy of the order in OA number?
OA number 2842.
2842 of? Just write down and give. Call after litigation. Can I return within few minutes?
Yes.
I come back. Transferred and pending there.
No.
It is put off.
No.
What happened to that? Give them. Okay. Yes, brother, he has already been reinstated and the petition has become infructuous and petition is accordingly disposed of. You consider his representation in the light of this, Mr. Lenka.
Yes, sir.
It is all, he has already been reinstated. That is your submission before the court.
Yes.
Take note. The short, so they call that order.
Hey, your Lordship, please kindly see the page 19.
19.
Yes.
Dated?
Dated 29/4/2025.
29/4/25.
Yes, sir. The letter was sent to the petitioner, which refers to the subject cited. I am to inform that promotion process of elementary teachers is under sub judice of the Hon'Ble High Court. Your case will be considered in the next district level promotion committee after obtaining necessary orders from the Hon'Ble High Court.
Which is that matter?
That I have to take instruction.
You have given promotion to his juniors.
Long since.
Huh?
Long since.
You give similar promotion to him and that will be subject to outcome of the petition.
Yes, I pardon your Lordship, but what is the, when the matter is pending, there is only in April 25. This letter has been issued to the petitioner only in April 25. Let me take instruction, my lord, otherwise.
Learned DG is requested to accept notice for.
Yes.
OPs. Any private party?
A private party that his junior has been implemented as a.
Number 10, notice to 6. You keep one copy with you and one copy you place by memo. All right. Yes.
Item 30.
May I please, Your Honor? The petitioner challenged the order dated 13th August 2025, in which the petitioner's legitimate claim for DNS allowance and medical leave had been rejected in a wrong-footing manner. The rejection order manner that is in Annexure 2 manner, Annexure 3 manner,
3.
page 23 manner, 22 manner.
13/8/25.
Manner.
It is rejected by which school?
That is the opposite party number 1 manner, Principal DAV School, Kalinganagar, Bhubaneswar.
Take notice.
Madam.
Emergency. OP number?
1, 2, 3, and 5.
1, 2, 4, and 5.
Four is the state.
Emergency.
No role, but.
Copy has been solved, my lord. Only 1, 2, 3, and 5.
1, 2, 3, and 5.
Yes.
Emergent notice. For Mr. Lenka appears.
Yes.
Yes.
Item 31.
It's covered by a lordship's order, my lord.
Take that.
Yes. Beginning the revision of pension of the petitioner, your lordship was directed to approach the authority and made necessary corrections.
You have made the correction.
Yes. Only name and
You have to make the representation.
Yes, your lord. That's right.
Yes, Mr. Manthi.
I'm gone. They have to make the press representation keeping in view.
Grateful, lord.
Item 32.
It's a matter. The Learned Tribunal allowed my case, and my execution case is pending from 2014 million. In the meantime,
14
million. In the meantime, lordship's order.
Last occasion, manner says by that Rahul Sir and
outside again altered now within 6 months now.
by the
Subsequent-
That was 1 year and subsequently by virtue of this new judgment.
Please go down.
Item 33.
33 may please, Your Lordship.
Yeah.
I put on for Your Lordship, my lord, there's an application under the writ of quo warranto challenging the legality of appointment, continuance and subsequent promotion to OP5, my lord.
Who are you?
My lord, I am the resident of that OUT, near OUT, I am the resident. My lord, as a further kind result, my lord, the appointment of OP5 is without the requisite qualification, my lord.
When it was done?
My lord, it was done on 8/8/2000, pursuant to 8/8/2008 advertisement, my lord. He was appointed on 2008, my lord.
8/8/2008.
Pursuant to that advertisement, he was appointed on 9/7/2009.
9/7/2009. Now you want to challenge that?
My lord,
Limitation for co-warranto.
my lord, the co-warranto, my lord, this is a, my lord, the co-warranto is a tool that is given for invoking the jurisdiction on constitutional courts, my lord. By what authority a person is holding the public office, my lord. Here, my lord, the limitation can be relaxed, my lord, because, my lord,
Show one decision.
my lord, the most celebrated judgment, my lord, of Govind Rao, my lord.
Mysore.
My lord, here, in that judgment, it was,
There the condition, the question of limitation did not.
no, my lord. And irrespective whether I'm affected or not,
1960 statement.
Yes, my lord.
Statement.
yes, Justice
Govind Rao versus Mysore.
University of Mysore, Mysore, my lord, by Justice Gadin, then Justice Hon'Ble Justice Gadin.
Which paragraph?
My lord,
You were not born, even I was not born when that judgment was rendered. No.
This is of sick days.
Now, 8/8/2008 is the advertisement.
my lord,
2009 is appointment.
my lord.
You want to challenge coronation of King Ashoka in Kalinga dynasty. How?
My lord, here it's an educational institute, my lord. And
Right? But he has been there how long? Suppose I am seeing similar such cases. I don't want to.
my lord had also issued notice in one of the such matters, my lord.
No case. What is the explanation?
My lord,
For this here, what is your age? Your means your client's age.
48, my lord, 48.
40. Therefore, he was when appointment happened. What was his age? 2009.
My lord.
2009.
2009. Subsequent, now he's getting promotion also, my lord.
That's all right.
My lord, the nature of the public office is getting changed, my lord.
Once your challenge to initial appointment is belated, that was. Then rest of the things in the structure, superstructure, that also will go on like that.
My lord, but here's a continuous cause of action because my lord is
No.
still holding the public office, my lord. My humble submission, subject to my lord's correction, my lord. Here, my lord, my statement is that he was holding the office without he entered into the service without the requisite
What are
qualification.
you doing in your life?
My lord, I am a small businessman, my lord. My daughter also used to study in OUT, my lord.
She studied under him only.
My lord, yes. My lord, I have the information that she was also studying, my lord.
She studied during what period?
My lord, that instruction I don't have exactly the date, but she was studying in OUT.
He gave a less number of marks to your daughter.
No.
Yeah. Now how? That's very highly belated.
My lord, it's
What Basu says on law of Coranto.
I'll place it, my lord. Rajesh Avasthi case.
What is the statement?
My lord, first is
No
Rajesh.
limitation for Coranto.
My lord, no limitation as in when in Govind Rao it has stated that when there is a hint before the honorable court that a person is holding public office without authority, my
No,
lord.
that is all right. But for that also there should be always limitation. Though our Constituent Assembly did not prescribe any limitation, but there are judgment, judicially evolved judgment. One who seeks a constitutional remedy, he has to come to the court at the earliest point of time.
Reasonable time.
Reasonable.
My lord, this is what, my lord, he had been trying to get the qualification and all through RTAs and all, my lord.
When he made the efforts.
My lord.
When he came to know, when he made the effort. After his daughter passed out,
My lord, my
That
lord,
must be the alternative. Maybe that daughter was not given.
my lord, here the question, my lord, not with respect to the daughter, my lord, the main question arises is,
You said that. I did not know anything about
no, my lord had asked me what was what the present petitioner is doing, my lord. My lord, I just informed.
That's why. You said that his daughter was studying in the same campus.
Yes, my lord, she was studying, my lord.
She was studying.
She was studying.
When she passed out.
My lord, that information I do not have. If my lord may permit me, I'll get the information. But my lord, my only stand is that the co-variant for writ is maintainable when the honorable court is satisfied that a public office is held by an authority who is not educationally qualified, my lord. My lord, that judgment I just gave, my lord, here that
That's
has been
true.
clarified.
But question is, at what point of time?
My lord, that has not been answered in the
I will answer now. I will answer. No, I cannot.
My lord, in a similar matter, my lord had issued notice in the division bench, my lord.
In these questions C, similar matters mean so many things. Have you produced the copy of the petition in that?
My lord, I have the petition. I have the petition. I have not produced, but I have the petition in similar.
No,
my lord,
this
here,
question is court raising.
my lord, here, this present petition also, my lord, I have filed by citing the educational qualification, this Rajesh Avasthi and the state of West Bengal and Anindya Sundar Das, my lord.
He does not have.
The same question, my lord, with respect to qualification.
I am not on that at all.
My lord, and the belated stage only.
On the premise that he has no qualification. Now question me, how the 2009 appointment, 2025 you are coming before the court.
My lord, 2009 appointment, but he had a certain time period in which he would have got that qualification, my lord, because the net qualification is mandatory, but it can be relaxed when he has PhD degree before 2003. And my lord, if he doesn't have the PhD degree and the net qualification is relaxed, he has to pass within 2 years. So, my lord, there is a continuous cause of action.
If he does not pass in 2 years, what will happen?
If he does not pass 2 years, his appointment shall be.
Where is that?
My lord, I have produced that document. Annexure 5, my lord, may kindly see. Page 32. The notification December 9, 2004, my lord, the letter, the registrar. General cater for giving exemption from net. The last, my lord. In case net exemption is granted in view of special circumstances, the candidates be compulsorily required to clear net within a period of 2 years from the date of issue of communication of exemption by UGC, my lord. And here in the present case,
Then where is that? If it does not pass, what will happen?
my lord, net is a mandatory clause, my lord.
I'm asking you, where is the UGC? If you do not pass, you have to go out. Where is that? He may not be entitled to many benefits and other things. Where is the taking away the post? It's a very serious. Where the UGC regulation says, if you do not pass, you have to go out.
My lord,
the campus.
Page 22, my lord, it says that it is mandatory to enter into the service.
Enter, having gained entry,
My lord.
what will happen?
My lord, it should be reviewed, my lord.
No.
My lord, here.
No, not that.
My lord, for a moment, page.
Of Apex Court, Justice Venkatachala of the Apex.
My lord also knows the judgment of Haryana, my lord, more modern company versus state of Haryana, my lord.
Hold, I do not know what is that.
That judgment, my lord, it has also said that a writ of quo warranto will be admissible at a point of time where the qualification comes into notice. My lord, I have also given.
No, but the question is not that. You cited, drawn attention of the court to the UGC regulation.
My lord.
Where the UGC regulations say
My lord.
that if you do not acquire that qualification within 2 years, you will be discharged from service.
My lord, it does not say in that particular verbatim, it doesn't say, but it is mandatory nature, it says.
It would that's all. But if it where consequence is not mentioned, the Apex Court said, where the consequence of breach is not mentioned, such a transaction, the rules shall be treated as directory.
My lord, here, when the mandatory clause is not other to, my lord, the main problem is that it's an educational institute, my lord, and without qualification, if it is coming to the position of associate professor, my lord, then the, my lord, education, the fate of the education system would be detrimental. My lord, may you kindly see page number 29, my lord, for a moment.
No, if you are a very good lawyer, very persuasive, all right, but I am a bad judge, I am not being persuaded.
My lord, I bow down to that, my lord. I bow down to that, my lord.
You are a good lawyer. You are answering things very beautifully. But the justice of the case does not warrant interference.
My lord, here for a moment, my lord. Page number 29, my lord, my kindly see.
There is
Compulsory, my lord.
it says compulsory, but that is not directory. That is not mandatory. Merely because it says compulsory, all rules are meant for following only.
Man,
What else for they are? They are for follow compliance only. But the jurisprudence of interpretation of statutes differentiate. Where consequences are not mentioned, the rule should be construed as directed. There are judgments. You look into them and come back. Or you want dismissal now only?
my lord, no, my lord. My lord, if my lord may permit me, I'll look into that. But my only submission to that extent was because it's a public authority, it's a public office.
Heard learned counsel for long. And as of now, court is not convincing of merits of the matter for granting indulgence. However, counsel seeks some more time to prepare more and come back for the war of the wit of call of vacation. What daughter was doing, etc.
Must get.
If the lordship will permit, can I intervene for a moment?
To submit, during which period his daughter was in the campus, and what are her educational credentials that are acquired in the said university.
If the lordship will permit, can I intervene for a moment?
Who are you?
I'm item number 1. I think I'm told that your lordship called me. I was absent at the relevant time when met.
Yes, sir. That is item number 1.
Item number 1. That's probably become infructuous. I don't have any paper, my lord. That's why I'm very sorry for the inconvenience, but because I didn't have paper, I thought that it will be dismissed for non-prosecution.
Say it has become infructuous and you can go on with the construction project in question.
No, I don't know. What is the matter? I don't have any paper. Excepting I had appeared, the client didn't give me any paper. I don't have the case record also. I don't know.
If you come here, I will share papers with you. I will not give time. It is 20.
No, I'm not asking for time. I'm not asking for time. Your lordship may ignore my appearance.
No, you are. Can I ignore? You have appeared, you have petition, you have said.
I don't have any instruction. I don't have any instruction.
Anyway,
the is very old. The client is not coming. What can I do, my lord? I don't have any type of instruction, including the material instruction. That is not very important, as your lordship called me, and I'm very sorry that ordinarily very many people dismiss it, but your lordship called, and I was, in fact, I'm not so well recovered from a past surgery, so I'm not that able to become regular to the court.
Anyway, say 2 words at least on merits, so that I will say you have argued the matter, because you just take. Do you have papers? You don't have papers.
Myself, I don't have any paper. I don't have any paper.
Second set of papers. You are from which place, sir?
Cuttack. Cuttack, my lord. I'm
send a copy to your house now. You just go through and make submission at 2 o'clock, 3 o'clock.
Only to your lordship's assistance, but it is without instruction from the client itself, it will be proper.
Necessary. It's a matter, all papers I will send to you now. The instructions are necessary to cross-examine the opposite party, etc. Yeah. One set of papers, take that, court vehicle and give to. Can we send a soft copy to you?
Lord, that is difficult. I am not that computer savvy.
Okay. As I am.
Yes.
I'm also illiterate.
Yes, I have become old, my lord. I am 70 plus.
Don't look to me like that.
Now I can't have the privilege to have the knowledge of computer.
I send one copy to you. First now, then give copy and serve it to the council.
A clerk was there.
Yes, sir, I am sending my clerk. I am sending my clerk to my friend.
That becomes easy. Yes. Ask him to give one set of Xerox. Do Xerox here only. Yes.
And that is, my lord.
At 3 o'clock, madam.
At 3 o'clock.
What is the case?
The advertisement issued opposite by opposite number 4 to fill up 3 posts of lady cook cum attendant. In advertisement issued opposite partner 5 to fill up 3 posts of lady cook cum attendant. In lady cook cum attendant. Cook.
Okay. Cook attendant. Somebody.
Cook cum attendant.
Yeah.
I was selected.
Yeah.
Selected. Issue order of appointment also. And that is annexure 2, page 20. Page 20, annexure 2.
Yeah.
3% given appointments with 3.
Yeah.
Without any notice of the so-called, my appointment annexure 3 was quashed. But
Quashed by which High Court?
no, sorry, my appointment that was cancelled by the same opinion to annexure 3. I approached my lord in earlier case, annexure 4. My lord, after hearing the parties, decided that no can be passed without giving opposition hearing to person concerned. Relying upon that Vasudev theory case, their theory case also quashed the order.
Yeah.
After question, I am not allowed, till that we are not allowed to resume my duty. In the time, annexure 5 being issued under page 28, my lord. So notice to me. My lord.
Yeah.
And
What was the charge?
no charge, only so-called no annexure, my lord. Only allegation. There is some kindly see page 25, 28, paragraph 2.
What is it?
Selected for post of so-and-so in violation of SOP for engagement CPCC. No, it is a class 4 post with limited scope. CCA issued by violation so-and-so fabricated advertisement and written examination papers.
Fabricated advertisement.
Advertisement issued by the opposite partner of 5. We applied, selected, matter, the selected submitted to collector. After that, opinion to verify the issue of appointment.
But the collector did not know it was a fabricated advertisement.
And advertisement annexure 1, that advertisement annexure 1, page 17. Page 7. Yes, issued by the opinion of 5, headmaster of the school.
That is fabricated, is the case.
No, that is cannot be fabricated because all persons applied, 7 persons applied. Selection was held. We selected. They are selected, submitted to collector. Verification approval. They are not approval.
Then they came to know that it is fabricated.
How can no document, nothing. Only allegation, annexure 5, kindly see 1 paper only. Fabricated document. No document and nothing, my lord. Kindly see annexure 5.
How many people were appointed?
3 persons. 3 persons, 7 people. That is engagement within my lord. That school area. It is considered pay 600 rupees per month to the ST women candidates specifically.
That's all right. But once fabrication charges.
Fabrication, then nothing, my lord. They are advertisement. We applied selection list for selection conductor.
Notice. You take notice.
And until that, I am not a limited solution, my lord. Despite that termination
issue emergent notice. Mr. Mahanti, PG requested for notice for all OPs.
Yes, sir.
All OPs. All this matter immediately after vacation. Yes.
I have filed IA, my lord.
IA will be considered along with.
No. I have filed IA for 2 grams. One for not to protect any further person answer 5. Second, I have discharged duty for 4 months. They are not supplied my salary.
Let us file the comment. 1 to 4 I can appear. 5 notice be issued.
What then notice to file? Post immediately after service.
Till that, no person answer 5 minutes.
Till date,
Annexure 5.
order. Till date, no increment. Yes.
Item 35.
Yes.
Item 35.
Annexure 5 only it is so cause, madam.
So no documents, no documents,
You ask that to them. They will give you.
Application only allegation and just allegation.
Let us. Yes.
May I please your worship?
Yes.
Madam, the present petitioner is a big pharma, my lord. He has accused big
Register him as a pharmacist.
pharmacist. So the inaction, I have approached this honorable court because of inaction of the opposite party number 3 in registering my name as a pharmacist.
Under Pharmacy Act.
My lord, under
What is
pharmacy.
the qualification you have?
He's a B pharma, my lord. Bachelor degree in pharmacy, my lord.
Once a B Pharma is done, you are entitled to be registered as pharmacist.
Pharmacist, my lord.
Which rule?
But that is the Pharmacy Act 1948, my lord.
Read that section.
So that is, my lord, although I don't have the act, my lord,
But that is usually, that is the difficulty is that why they are not taking any action, my lord. That I am satisfying your lordship.
But you have to satisfy the law first. Which law says? You said Pharmacy Act. It is like saying a constitution.
No,
Which provision? Once you do your B Pharma degree, M Pharma degree, you should be registered as a pharmacist. Which is that rule?
That is on the
I want to know.
Indian Pharmacy Act.
No, I do not know that. Pharmacy Act has many provisions.
But it may be taken up tomorrow, my lord.
Kindly, you don't have book also. Pharmacy Act. Just ask anybody. I call after occasion. Yes.
My lord, we are appearing for OP number 2.
OP number 2.
They don't serve copy on the.
Why they should, sir? Have you entered a KVA? He need not serve.
We are appearing for Pharmacy Council of India.
Pharmacy Council of India, they let them.
Before the admission is done.
The case has not been admitted, so no.
They are not admitted yet also.
Let it be admitted.
You can't solicit notice. It's misconduct under the Bar Council rules without entering KVA. Otherwise, all Cuttack market people will come and say we should be out in the matter. What I should say. Therefore, either you have to file the KVA or you have to wait till notice is issued. Or you have to show the rules which says every petition filed against Pharmacy Council of India shall not be presented before the court unless advance copy is served on it. For state, there is such a rule, but not for you, not seen such rule. Let us see wait. Now you have made representation.
My lord, I have made representation to the Pharmacy Council of India. I have also made representation to the OP number 3, my lord. That representation has not been inadvertently annexed, my lords. The OP number 3 is competent to issue the.
Who is OP number 3?
That is Drugs Control Law, Odisha State Board of Pharmacy, my lord.
He registered.
He registers, my lords.
Not Pharmacy Council of India.
For the state of Odisha, he has been authorized
to register.
Yes, my lords.
Accept, now you issue notice. You may accept if you want. Yes, issue notice.
Well, can it be disposed of with the direction to consider my representation OP number 3, my lord?
Can it be done? To consider you, OP number 3.
3, my lords.
Short grievance of the petitioner is as to non-registration of non-registration as pharmacist as provided under the provisions of Pharmacy Act 1948, 1948, and the rules and regulations promulgated thereunder. First of all, Learned Counsel for the petitioner surveys that a representation has been submitted on 5/8/2025 to OP number 3 to effect registration depicting the petitioner as a pharmacist so that he can take up occupation in relation thereto. First. Next paragraph. Learned Panel Counsel Shri. So, up you go to first item. OP number. Learned EGA Mr. Mohanty appears for OP numbers 1, 2.
1, 3,
and 4.
3 and 4.
But the representation is to OP number 2.
Well, OP number 3 I have already submitted representation, but these are not been annexed models.
This has not been annexed, but who is annexed?
Yeah. Learned Panel Counsel Shri so appears for OP number 2, Pharmacy Council of India. First one. Next paragraph. Mr. Mohanty points out that no decision can be taken by these clients since no representation is given to them. First one. What is your submission?
We don't receive any copy.
You have not received copy.
Generally, this Union Council is appearing for Pharmacy Council, Nursing Council, then serving the advance copy, then only you getting instruction. As you have not received, that's why I asked Mr. Patnaik to appear and assist the court. Let them. Yes.
Anyway, we will just consider the representation.
Yes. Let them survey copy will be sent the instruction according.
Learned AST assisted by the so-and-so appears for OP number 2, and submits that. Had the petitioner given a copy of petition or at least a copy of representation, he would have instructed his client to look into the grievance of the petitioner. First one. This is a fair stand. Next paragraph. In the above circumstances, petition is disposed of, permitting the petitioner to make appropriate representation to the concerned opposite parties within 2 weeks.
Your Lordship, number 3.
When is made, the same shall be considered by the jurisdictional OP in accordance with law within an outer limit of 8 weeks. All contentions are kept open. Petition disposed.
May I pray, my lords? Your Lordship, say OP number 3, but that is...
We do not know. Because suppose if they have a room, because you have made all of them parties. Yes, therefore, you send representation to everybody. Whoever is having authority, he will do that. That will ease your task. Otherwise, you will come. They will say, we don't have jurisdiction. Again, you will come here. Therefore, the omnibus order is made now. To all these petitions, correspondent OPs you can send. Next paragraph.
Item 36.
In fact, structuring the prayer is a great art. It's a great art. How you should structure the prayers. That you will know if you read Moga, PC Moga on pleadings, Odisher on pleadings, Shiv Gopal on pleadings, Indra on pleadings. Then you will know how we can save lot of court fees. Sometimes a lot of court fee you will be able to save if you know how to structure the prayer. Yes.
In this case, petitioner who is a retired headmaster, my lord, is claiming his third MSCP benefit after the completion of 30 years service, my lord. Similar judgment.
Mr. Monty, will covered by the judgment. Yes.
Your Lordship's judgment.
Yes. Same. Have you changed the dates and other things?
Yes, ma'am.
Item 37.
May I please, Your Lordship? The petitioner filed this writ application challenging the order of rejection order Annex 8 for regularization of the service as nationally from the period of
NT.
Yes.
What we have done with all matters are pending or disposed of?
This is earlier. This is fourth round litigation, my lord.
Third round litigation.
Fourth litigation.
Then you take notice. They have rejected that.
Yes, ma'am.
Yes, ma'am. That is the impugned order here.
Learned AG request issue notice. Learned AG requested to accept notice for all OPs.
Yes.
Next.
Well, a fixed short date for a retired person of release of pensionary benefits, ma'am.
Post in the 3rd week of October. Yeah.
Item 38.
Item 38, may I please, my lord?
Yes.
This is a matter challenging. I'm challenging the order under Annex 15, my lord. So, no order passed by an appellate authority. Wherein, my lord, I am a builder, my lord. I constructed a building after an approval of plan. Well, subsequently, there was a deviation found in that said buildings, due to which UAP case number under 91 of the Woody Act was instituted. My lord, in that case, it was held that the deviation is compoundable in nature, my lord. And they directed us to file a regularization plan, which we duly filed it, and subsequently, my lord, they rejected that order, and subsequently I filed an appeal, wherein they have stated that, my lord, my C70.
And 5th floor.
Yes, my lord.
2 floors you have done.
No, my lord. No, my lord. The approval is B plus S plus 4, my lord. B plus S plus 4. Annexure 1. Yes, ma'am. Yes, my lord.
Basement floor.
Yes, my lord.
What is the difference between stilt floor and basement floor?
But stilt is the pillars that the
only pillars will stand upon that.
Upon that, the first floor will come. Yes, my lord.
This will be completely ventilated and
yes,
no restrictions,
yes,
nothing.
Yes, my lord.
Basement floor is the structure itself.
Yes, my lord.
My lord, there was a B plus S plus 4 was granted, but subsequently B plus S plus 5 was there. But the fifth floor is that there's a one small room. That is the only deviation there. They have directive for demolition, my lord. And, my lord, earlier they had said that it is compoundable in nature, my lord.
They had said now you have to show law whether a particular act is compoundable or not.
My lord.
It's not a matter of concession. It's a matter of law. You have to show the rule under which it is compoundable.
My lord, why I say it is compoundable? Because, my lord.
Because they said earlier.
No, yes, my lord. My lord, may please come to page 40, my lords.
40.
Yes, my lord.
Where they have said that.
Yes, my lord.
That does not make sense.
My lord, there has been no setback, my lord, as well. Well, subsequently, they are saying that it is a high-rise building which is above 15 meters in height. My lord, my humble submission is that it is within 15 meters, my lord. Because they have, my lord, they have added the still floor. My lord, under Rule 39 of the ODA rules, my lord, still floor will not be measured while measuring the height of the building, my lord. Well, the still floor height is 2.5. They, along with that, they have also added the measurement of the water tank as well.
Please repeat.
My lord.
While measuring the height of the structure.
Yes, my lord.
The stilt floor to be minus.
Yes, my lord. Stilt floor along with the water tank. A water tank, the water body where water is kept, my lord. What is stored? But that has also need to be excluded, my lord. But they have added the stilt floor.
Which is that rule?
My lord.
Generally,
my lord,
has something to do with the fire potential, etc. Because fire engines cannot pump the water up to that level. That is the reason.
My lord, the fire
code said the height is very essential.
My lord, the fire energy is required for above 15 meter of height of the building, my lord. We are saying that my building height is within 15 meters, my lord. My lord, may see page 15, para 17. I have quoted the rule, my lord. There.
Page 15, para 17.
Yes, my lord. May I read, my lord?
Yes. Exemption of the building.
The following appurtenant structures shall not be included in the height of the building, namely roof tanks and their supports with support height not exceeding 1 meter, ventilating air condition, lift rooms and similar service equipments, stair cover (Monty) not exceeding 3 meters in height, chimneys, parapet walls, rooftop, swimming pool and architectural features not exceeding 2.5 meter in height, height of the ceiling of the upper basement roof not exceeding 1.5 meter from the average surrounding ground level, and stilt floor if the height of the ceiling of the stilt floor roof is not exceeding 2.4 meters, my lord. When my lord may see the order of the appellate authority, they have not discussed anything about this, my lord. They have only said that it is not compoundable. My lord.
The question is not only height.
My lord.
You did not have,
my lord,
the approval for one whole floor.
My lord, it's not a whole floor, my lord. My submission is that it is only one room, my lord.
Only one room?
Yes, my lord.
Where is the building?
My lord, I haven't annexed the picture of the building, but it has been.
You may have some my quarters picture you may have and put it.
No.
No, we'll send you some lawyer from
please. But one Amina was appointed and he said that it is B plus 4, but B plus S plus 5. There is a report by the Amina that it is compoundable. The architectural assistant also said that it is in the UAP case, my lord.
No, that's not the question.
My lord.
Who will send some engineer?
My lord.
And let him report what is the what actually is the height, whether there is only one room as you are submitting.
My lord.
If it is false, then we will prosecute your client for perjury.
My lord.
I record your submission now.
My lord, there was Amina was already appointed, my lord.
You said that.
Yes, my lord.
Now I want to know.
My lord.
You are sticking to the stand.
My lord.
That there is only small room in the fifth.
My lord. My lord.
Is it not?
Yes, my lord.
We will ascertain it from sending one member of the parliament.
My lord.
The answering opposite party is 2 and 3. That is the BMC, exactly.
Yeah.
BMC and a city planner. And Omin is not the person to process all these things.
So
That is the architectural part and engineering part.
Correct.
That he has to go by this OD Act or BD Act.
Correct.
But the answering respondent is 2 and 3. Unless they appears, they can answer it exactly.
Take notice, let us see.
My lord, no coercive action till then, my lord.
No, I don't take that because you have seen what the Apex Court has pulled down 200 floor building, which is that judgment. The famous judgment, 200 floors were pulled down.
My lord, may consider because they have directed for demolition, my lord.
Correct. But you take emergent notice.
My lord.
Let us issue emergent notice. That the AG is requested to accept notice for 1. Emergent notice to 2 and 3. Next paragraph. The net counsel for the petitioner points out the application in IN number so and so supported by affidavit and seeks a non-precipitatory order. First of he tells the court that unless the impugned order is stayed, the authorities may pull down the building. First off, that apprehension he need not have, since this court is directing emergent notice to OP number 2 and 3. That particular.
Item 39.
May I please, my lords?
Yeah.
Here is the case, my lord. The petitioner, my lord, was there issued order of suspension, annexure 4, and thereafter, page 15. And listen.
What was the misconduct?
Misconduct, my lord, that the misconduct only not obeying order of higher authority and delegation duty. But that the not question is, my lord, I participated in proceeding continued for long period. I kindly annexure 9. I paid for final proceeding as a early time. That kindly pay 22.
22.
My lord, and listen. I filed a petition to proceeding may be closed at a earliest time, my lord. But without any inquiry report or seconds of notice, answer 10 has been passed to opinion number 2. That is my grievance. They are not followed the rule 1510, where it is specifically mentioned that after the inquiry completed, you have to give the inquiry report along with the second show notice.
Second show notice, is it not dispensed with the amendment, the 42nd amendment?
No, that not like
language that Ramjan Khan.
Ramjan Khan case is the Ramjan Khan that was amended. Rule that is issued under the rule. After Ramjan Khan case, 90 Supreme Court, Rule 15 was amended. OCS rules.
Rule 15 is amended.
My lord, kindly.
Saying
that it is compulsory for kindly amendment the Rule 15. Plus,
read.
My lord, yes.
We should be inquiry. Brother, whenever only one small 1 or 2 rules are involved, we should bring small Xerox copy so that it becomes easy for the.
I have brought the book, my lord.
Rules you have brought, but Xerox you have not brought.
Sorry, my lord.
Give that, we'll get Xerox here. Take 1, 2 copies of.
Yes. My book is rule. Rule is with my lord. This is rule, my lord.
Page number?
My lord, my page
to find out.
1510.
Go to
same rule for 46, my lord.
Go to 311
my lord,
of Constitution. Just take out somebody.
My lord, Rule 1510 Roman IA. If the inquiry, I got it. Rule 1510. 1510. My lord. Roman 1 IA. If the inquiry officer is not the disciplinary authority, the disciplinary authority shall furnish to the delinquent or government servant a copy of the report of the inquiry officer and give him notice by registered court or authorized calling upon him to submit within a period of 15 days from that such representation as he may be wished to make against the finding of the inquiry authority. 1510 Roman 1.
For a punishment also?
Yes, before imposing punishment, he has to submit furnish the inquiry report to the delinquent along with second so-called notice.
Second so-called notice?
Notice. Thereafter,
which rule is it?
That mechanism. Rule 1510 1A.
1510 1A.
A, my lord.
Then it's not here at all.
I wrote 46 such.
Tell you're right.
Yes. If the inquiry, I got it.
Inquiry officer is not the disciplinary authority.
The discipline authority shall furnish the delinquent government servant a copy of the report of the inquiry officer and give him notice by registered court or authorized calling
Upon him to submit within a period of 15 days such representation as he may wish to make against findings of the inquiry authority. Where is against the punishment?
Punishment, no notice issued to me. No notice, no inquiry report, straight to punishment. That is my case, madam.
Inquiry report was also
No, never communicated to me. That is specific government mandate by law. And they have, and that more, annexure 10 was the order of punishment. I filed the appeal. Inevitably, before opinion note 1, I should file opinion note 1. I filed opinion note 2. That is annexure 12 page 25. He should remit the matter to the opinion note 1 under rule 28. But he himself rejected my appeal, madam. Annexure 13.
because you filed appeal before him.
That's wrongly.
At least after filing the appeal, he should have gone and said, only I have filed. Kindly transmit the authority. Permit me to withdraw.
Employee is a layman. He is a junior clerk. Rule 28 of the pension.
He is engaged at very competent.
Before that, he filed himself. They have to come to me. After rejection of the appeal, he came to me. And rule 28 says if wrong is filed, it should be transmitted to the original authority or the LCC rules itself matter. If wrongly filed, it should not be transmitted to the authority.
Take notice. Take notice. He says that even Ramzan Khan is not followed. 1991 Supreme.
91 so. But notice has been issued.
No.
They are saying that second show cause.
Second show cause is there. I don't agree with that because Article 311
is there, my lord.
Amended. You can't have second show cause notice.
Half notice after the inquiry report, half notice, madam. After the inquiry completed, they have to submit the
inquiry report along with the show cause.
Yes. That has not been given to me. That has not been given to me. That is Ramzan case followed by the 94 Supreme Court also. Paragraph page 6, I have mentioned both their judgments, madam.
ECIL. ECIL.
Process B karna kara.
I am giving in paragraph page 6, I have mentioned, madam.
Now to take emergent notice. First time. Have you filed any application?
Yes, first they have annexure 10, madam. Punishment.
An application in IA number 20, so supported by affidavit is filed. First one, the consent for the petitioner submits that in terms of Ramzan Khan, 1991 AC, no punitive action can be taken without furnishing a copy of the inquiry report. First one, he also presses into service rule 1510 IA of OCS CCA rules 1962 in support of this version. First one, there is a case made out for issuing interim protection. First one, next one, in the above circumstances, application having been favored, the OP number 2, my lord. OP number 2 is restrained from taking any punitive action against the petitioner till next date of hearing pursuant to impugned order.
Lesser pain.
An example.
My lord.
Yes.
Item 40.
May I please ask? Read the case, my lord.
Yeah.
The petitioners were selected for the post of LSS teacher, Lower Secondary Education Service, Annexure 1, India 997. They students posted to high schools. No, they were posted to ME school after the notification of elementary cadre rules. Therefore, they approach the authority time and again for repatriation to the original cadre matter. Original cadre.
They were posted to
ME schools.
ME school.
ME schools.
ME school means
Middle English High School. Up to class 7.
They could not have been posted there.
They should have put in high schools, my lord. After 1297, there is no scope for the teachers LSS to post in any ME school. Because ME schools have come out of the elementary cadre after 1297. But Annexure 1, Annexure 2, they are appointed in ME school in 1697 Annexure 23.
Covered by Justice Shashwant Mishra's of judgment.
Additional court. This one, after hearing all the parties, I have the case. And my lord, kindly see only one document, Annexure 3, page 13, page 25. Annexure 3. Similar page persons selected in a portion ME school, they reported back to secondary cadre. Page 25, kindly see.
Ninnabetan Pradhan.
What they have done?
They have that man upon ME school, we are referred to secondary cadre in high school, posted high school. We are adjusted from government high school, Kurmule. That are taken not by single judge, well in the order. That is on page 45. That similar person has already been brought back.
Take notice and file up.
And this order has already confirmed on appeals court. And this order has confirmed on appeals court.
Let me take notice.
And I pray that in the meantime, what happened? Now the gradation teacher is in produced for junior assist teacher. They are never find place there. Even if we are eligible from 2010, then after judgment of decision court, they should have brought up. They have brought over to high schools, but again Lease is cut up. Whereas this one got specified kindly see, last paragraph kindly see.
No, that's all that I am convinced for admission.
But my interim is that the gradation may not be finalized. Gradation list of junior may not be finalized.
If they finalize, what will happen? If you succeed, you will get your position in the gradation.
At my submission is that they should have complied on this one. This order code. Only one time.
Yes, please.
I will have 5 representation before opposite part number 2.
Let us see.
Our submission, the pendants of this case shall not be back to consider representation. That is my condition. I have given the representation.
Representation is considered, you will be happy.
Pendants are not a bar. They may consider.
Next. Item 41.
The petitioner while working as assistant teacher in government high school, he was faced a disciplinary proceeding where the punishment was imposed.
Fixed date matter. May I please also be fixed date matter? Item 40.
Admission matter, no?
And item 40 after vacation any date matter.
Posted in the last week of October.
Madam.
Here the petitioner while working as assistant teacher in a government school, he faced a disciplinary proceeding where Annex 7, the punishment order was passed way back in 2014 by 4 increment of withheld with cumulative effect. Against that matter, he filed an appeal on Annex 8 through proper channel. Since 2016, 4/8/2016. Now the appellate authority rejected my case after 8 years, Annex 10 page 45, indicating as if I file appeal in 2023, which is 9 years delay. Therefore, dismiss my application appeal on the ground of delay.
You made it well.
16 Annex can see page 8, Annex 8, page 37.
You look into
4/8/2016.
9 years.
Whether it is true or not.
9 years.
Punishment was issued on which date?
14 date that is
Punishment is at
21/3/2012.
16/12/14. 16/12/14. Annex 7.
2014.
16/12/2014. When did you file the appeal?
4/8/2016.
What is the limitation period?
90 days. Under the rule, 90 days.
90 days.
Yes.
Any rule for condonation of delay? There is no condonation of delay. Other day, somebody argued. I asked
There's a provision, provided that the appellate authority may entertain the appeal after expiry of the state period if it is satisfied that the appellant has sufficient cause for non-submitting the appeal.
Where is your application for condonation of delays?
The application.
Annex 8.
Annex 8.
Annex 8.
Application for condonation of delay.
Also, look at the ground. Why?
Where have you stayed? Read.
Madam.
9.
That exactly is one of the delay part has not been stated in the appeal petition.
Nothing.
Now, Annex 10, they have the appellate authority. I have made a reminder in 2023.
He should have dismissed it on the first day. He delayed it in dismissing. But you have not said anything, one word, as to why you were going to him with lot of delay.
But the appellate authority, what I said, also kindly see, they have indicated as if I made appeal in 2023.
That's all it. You made the appeal. You have
16.
made on 16/12/2014.
Yes.
You filed appeal of 1/4/8/2016.
That is not that.
You did not utter one word about condonation of delay, saying I am not well, my wife is not well, children are not well, they are studying. Nothing.
Then that part in the appeal petition is not there. But the ground of rejection is something different. That is my interrogation.
Maybe it makes no. It does not. This where we read section Section 3 of the Limitation Act.
Yes.
That is extended to these appeals also. Whether contention of delay is taken up or not, the court should dismiss the delayed procedure. But petitioner suffered a penalty order dated 16/12/2014 in a properly constituted disciplinary inquiry. First, against the said order, he preferred a departmental appeal on 4/8/2016. 6/8/2016, which came to be dismissed by the order dated
10/6/2025. 10/6/25. Unaccepted.
First, learned counsel for the petitioner vehemently argues that the appeal could not have been dismissed, notwithstanding the delay proved in approaching the appellate authority. First, learned AGA, on request appearing for the OPs, draws attention of the court to rule. Which rule?
Rule 23, madam.
Rule 23.
And the OCS CCL.
OCS CCL rules so and so, which prescribes a period of 90 days for filing of appeal. First, learned AGA submits that although there is a provision for condoning
Rule 24.
Just look at
24.
Although there is a provision for condonation of delay, that power becomes exercisable only when the grounds are made out, sufficient grounds are made out therefor, and not otherwise. First, at this stage, learned counsel appearing for the petitioner turned the pages of the petition book and very fairly conceded that in the appeal memo, not even a word is whispered as to why the delay is proved, nor any prayer is made for seeking condonation of a long delay. First one. Next paragraph. Learned was agreeing with the contention taken up with the learned AGA, this petition is liable to be dismissed, rejected, and accordingly is course and yeah.
Yeah. I may pardon
Item 42.
The transfer case where your lordship, given the intent protection, and not continue the said school and highlighting the ombration, the golden opportunity. Here the same incident and same fact has been given. And they also.
Yeah. Yeah.
May. But the petitioner is a lady lecturer in botany who has faced 2 transfers and 1 cancellation of transfer order in her short span of 3 years of service. Your Lordship, I have a glance at the annexure 3, Your Lordship, 21. This is the second transfer order. Page 21, my lord. The following lecturers, readers, non-government aided colleges are hereby transferred and posted as to the college mentioned again. And my serial number is 10. It is from Chorampa College to Surendra Narayan College, Rajkanika. And this order, my lord, you also can have a glance at page 22. It has been issued by order of the governor, special secretary to government. And this order is passed on 25th June 2025. And in pursuance to this order, the petitioner has joined on 1st July 2025. And she has been working and she has also been paid his salary. While the matter stood thus, without jurisdiction, the Director Higher Education, you also kindly have page 28, now issued cancellation of transfer order. You also 28, my lord. Page 28.
Annexure 5.
How governor's order can be cancelled by director?
By the order of the governor, this is not.
It is by order of the governor only.
Yes, my lord.
It cannot be, my lord, after I'm satisfying, my lord. The transfer order of the following teaching staff of non-government colleges issued by this department is hereby cancelled. My serial number is 2. But here, I will also calculate Director Higher Education. But Director Higher Education since 2020, Director Higher Education has been divested of its power in respect of teaching staff. You also kindly have a page 30. 30, man. This is the order issued by the Commission Come Secretary. It is also by order of the governor. My lord, may I permitted to read? In pursuance to Rule 2B of the Orissa Education Recruitment and Conditions of Service of Teachers and Members of the Staff of Aided Education Institutions Rules 1974.
The other person has to act as director.
Other person was the secretary.
Will continue to
special
exercise his power under said rules as the director in respect of the non-teaching.
My lord, the director has no jurisdiction to pass this order. And again, this special secretary's order has been here cancelled.
Yes, appears to be the correct submission. For two reasons. Whether the transaction of business rules. See, governor means it's a shorthand, 1980 Supreme Court, which is that judge famous Maru Ram versus Union of India. Take out that. 80 Supreme Court, Constitution bench. President is the shorthand for the central government. Governor is the shorthand for state government. So governor as such will not take this. Correct. On behalf of governor, some authority who has been designated in the transaction of business rules or allocation of business rules to made under the Constitution, they will take the dish. Now, the power of the director is confined to non-teaching staff. How can he do that? It is that Maruram, did you take that? Maruram versus Union of India. Yeah, 1980. So not Constitution bench judgment it is. 1980. Here 1980 SC, where is that?
That is Constitution President, my lord. Maruram.
1980 AR 1980 SC 2147.
1980 AR 2147, my lord.
2147.
My lord.
If that is so, how can this director take a decision? Take now. Issue emergent notice. First of all, counsel for the petitioner draws attention of the court to application in IN number so and so, supported by affidavit, wherein interim protection against the order dated 31/7/2025 is sought for. First, learned counsel for the petitioner tells that the governor had made the order on 25/6/2025, and accordingly the petitioner joined the transferred post with effect from 1/7/2025. First off, that being the position, the director could not have made the same. First, he also tells that the powers of director now have been drastically reduced and are confined to Matters pertaining to non-teaching staff. Staff first. Thus, the case, prima facie case is made out for granting the interim protection. First, next, in the above circumstances, application having been favored, the impugned order dated 31/7/2025 is stayed till next date of hearing. Petitioner is permitted to continue in the institution wherein he or she was serving immediately before the issuance of impugned order.
Yes, my
Wish to facilitate implementation of this order. Yes.
in SN College, he has been serving in SN College, Rajkanya. That would be
Very well.
1 to 4 is the government, 5 is the.
I will take it. Obliged.
Item 43. 43 matter relating to fee hike. Now, this is second round of litigation, Lordship. Kindly see the earlier order of Lordship. Your Lordship specifically directed OP number 2 to consider the grievance which is pending for him. And till he takes a decision, this Honorable Court suggested that 10% hike would be permissible and we are allowed to pay. Now, the OP number 2 has rejected our representations, quoting the submission of the petitioner this side and that side, and said that you have to maintain this, which is the judgment of this Honorable Court. A fee structure committee headed by Honorable Justice K.P. Mahapatra, as he then was. He was the head of the committee. He has fixed the guideline, how and under what circumstances fee would be charged. That his lordship has fixed that he has to maintain surplus fund from 6 to 10%. We have categorically calculated your surplus fund, what is the requirement, what is the previous year's requirement, present year's requirement, and the projected requirement. We have calculated, taking into consideration the inflation of the state country, that if 8% would be calculated, everything will be sorted out. The LRC impugned order page 138, just quoted the submission of both the parties and simply quoted the language which the Honorable Court has delivered.
No, the coordinate judge
Yes.
only said consider the representation.
That is the only.
And last part you will can see.
Till a decision is taken.
Yes.
Yeah.
The 10% were allowed. We have been paying millers. We are agreed to that because we see that if the Honorable Court's finding that the government audit should be made, the audit report should be published on the website, and the paraphernalia has to be maintained. They are not maintaining this side. And we are insisting before the OP number 2 that kindly call for and ask them to do this, reconstitute the managing committee, do this, do that. That is our grievance. But he has nothing said about that, and just simply accepted that this should be followed. The grievance remains at is nothing sorted out.
He thinks he is the Mughal of this country. Yes, where is the consideration?
Here the opposite part number 4, 5.
The private.
They are the private management committee of the school.
Very good.
6 is the CBS authority who has given permission. It is a CBS pattern. So far the committee.
Where is the due consideration of the representation? He has said one version, other said, and therefore, where is the treatment of the subject? You take notice, emergent notice.
For OP number 1,
after service.
1 to 3.
1 to 3, Mr. Bhundi, emergent notice to the rest. Both on main matter and application. All immediately after vacation.
Entry millers?
No entry model.
Because we have been asked to pay. They have
paid.
You'll also kindly see. The interim order, the paragraph 6 of that order.
I have seen.
Till a decision is taken, Lords will be prejudiced. Lords, you also kindly see, I have enclosed one document.
For the petitioner presses for interim relief. First. no case is made out for the grant of same person. Our application will be considered after objections are complete.
Milords, one parent withdrawn his children because they could not meet the fees.
That is, yes, yes.
Milords, kindly do the interim order which was passed earlier.
No.
May continue, Milords.
No.
We are ready to pay and we have been paying, Milords.
No.
Subject to your lordship, if lordship considers that we are entitled to pay much more than 10%, we will pay, Milords. We undertake.
That is, yeah.
But this was your lordship, can come to the post student.
You should allow others to argue them.
Milords, that's
Instead of rejecting
my
the-
persuasion to lordship that
I don't want to get become anguished by your submission because your clients will be pressing you. That's another thing. But they should know your limits also. Is it? If you go on arguing.
No, Milords, I am not going on, but this was the earlier order that I was insisting that.
You have said, I have seen paper. That's the, it's not a case where interim order should be granted without hearing the other side. Yes.
May it please, Your Lordship.
Yes.
Lordship, the petitioner has challenged the action of the opposite parties in not sanctioning the revised pension and fixing the pay at level 9. Lordship, the petitioner was appointed as an assistant teacher in the year 1987 and he was...
You made a representation.
Your Lordship, may kindly see Annexure 4.
And the page number?
Page number 14. Your Lordship, the petitioner had approached the block education officer, Loisinger, and he had sent the documents of the petitioner. Blessed.
PG for all office.
Yes, Your Lordship.
All office. Next.
Item 45.
May I please, Your Lordship? My Lord, this is the fourth round journey of the petitioner, my Lord. In fact, 3 read petitions and 1 contempt petition, my Lord. My Lord, since this case has got a checkered history, my Lord, I have just prepared a small brief note of submissions and a little memo, my Lord. If Your Lordship
may be permitted to interrupt. As per the earlier direction of this Hon'Ble Court,
Brother Judge.
yes, the opposite party has filed this affidavit therein that the order impugned therein, which is under challenge, that has been withdrawn and they have sought for 2 months' time to make it convenient and pursue by the collector, who is the authority concerned in case of Sikha Sahib, to pass a necessary order. That affidavit in pursuance to this order of this Hon'Ble Court has been 5/6/2025.
Why?
This is filed by the
to me, my Lord.
It will not apply to
district welfare officer.
Why it will not apply to your sister?
My Lord, no, my Lord, sorry. The affidavit filed by the DW not supplied to me, not sought to me.
You
Right now.
You only have produced it, no? You have not produced it. She has not produced it. The affidavit which now you are saying that it has been withdrawn. Where is that? Where you are finding it from?
My Lord, it is with the file, my Lord.
In your file?
Yes, my Lord. It has been filed on 6/5/2025 on e-filing.
Just share copy.
Right now I can suppose.
Observation.
Interim order earlier passed and continued.
Was there interim order?
Yes, my Lord. Since 2016, one post kept vacant, my Lord. That's why I may file a memo of citation, also the written note of
My Lord,
commission.
that in course of the day I am filing it. So, if it will be put it after vacation, by that I can take the positive instruction. In the meantime, what has happened and what is the proceeding all about to end of this matter.
Call the observation as of for the who assures to come back with the counter in full inspections.
I'm serving the copy right now.
In the meanwhile, you have served also.
Absolutely.
Okay, call this matter. There was interim order in this matter.
Yes, my Lord.
Interim order was granted on?
Hello, interim order was passed to keep one post vacant, my lord, till the next date, my lord. Order dated, my lord, 6/5 to 2025, 29/4/2025, and my lord also.
Justice Shashikant Krishna. Interim order granted on 6/5/2025 by the coordinate bench to continue to exchange of the. Yes.
Item 46. Item 46.
Item 60, putting it upper vacation.
After litigation. Any question?
Not this matter, earlier matter.
After litigation.
Exactly.
Yeah.
Item 46, Your Lordship, last night the opposite party number 4 has served a copy of the counter affidavit to me, Your Lordship.
I have
Your Lordship.
copy of petition has served. So I filed a counter objection to the said petition. I have already served copy.
I need to file a rejoinder to this, Your Lordship.
Permit me, I can file on registry.
I think the call it after vacation.
My lord.
I have instruction to appear for opposition party number 3. If my order will permit me, I will file my BNM here or I will file
The registry.
Item
Calling 30 Yeah.
Item 47. May I please yours?
Yes.
My lord, the appellant has, my lord, have a glance the flag mark 35 for a moment. The appellant has filed a IN number 834 of 2025 seeking deferment of the hearing in the present FAO. As the order dated 6 December 2024, Your Lordship, has been not fully complied with. In view of this, we have initiated the contempt proceeding by filing D contempt number so and so, which was pending for the consideration, Your Lordship. So we respectfully humbly submitted outcome of the contempt application will have a direct being to the present appeal. Therefore, in the interest of justice, we pray that the hearing of FAO be deferred with the contempt matter is decided, Your Lordship. So kindly have a glance, order dated.
Which is that UP matter?
FAO matter.
No. Go to pray.
Item 38, Your Lordship.
7, Your Lordship, the petitioner, I may be permitted to withdraw.
You want to withdraw? Which petition you want to withdraw?
47.
47. Tell the number. You may withdraw other petitions.
22083 of 2020.
To file a give them copy. Learned, what's your name, sister?
I'm appearing on behalf of Durga Prasad Nandas. My name is Dipanvita Naik.
Fine. So appearing for fine. So as fine on instructions of the client that petition may be disposed of and not placed. First, memo is taken on record. Next, WP disposed of accordingly. Yes. Yes, brother.
Item 48. In this case, kindly have a glance the flag mark 35, Your Lordship. The appellant have filed a IN number 834 of 2025 seeking for deferment of the hearing of this present FAO.
FAO number 471 of 2017. 2017 matter, 8 years are over. Still it should be deferred.
My lord, the circumstance as such, because of the order dated 16 December 2024, they not fully complied still date. That's why we have already filed a contempt, D contempt number, so and so, which is pending before the Honorable Court, Your Lordship, for the consideration. But kindly have a glance the 16th order, Your Lordship. Have a glance for a moment, Your Lordship.
16?
6/12/2024 order dated. Of the present FAO.
6/12/24. December, 6 December.
Lord, may I clarify your lordships?
Yeah.
Lord, by virtue of two orders of this honorable court, my lord, the matter was referred to the crime branch relating to certain documents.
Which is genuine.
Yes, on the basis of the petition filed by the appellant. Your lordship may kindly see.
Crime bench.
Yes, crime branch.
It should be referred to
Forensic.
forensic.
Yes, my lord, crime branch it was referred. Your lordship may kindly see the order dated 6/12/2024.
Yeah, 6.3, I find it.
Yes. My lord may kindly see three documents were
What happened with the CID?
My lord, they have submitted a report and copy has already been supplied. My lord, yes. My lord, your lordship may kindly see 4 to 5 documents were, my lord, referred to the crime branch. That is at.
Now, what the crime branch said?
Crime branch said that the appointment order issued in favor of the appellant by the governing body, that is a genuine one. And the appointment order annexed by the appellant, that is not available in the college records. And secondly, the appointment of the opposite party number 4.
Not available.
But he was never appointed. He was never appointed on that date. Now he has raised a claim in this appeal that he was appointed on
In the first page, 1991.
No, not 91.
Not 91.
But he was appointed on
Put a page,
first page. Well, the dispute is the
1191.
No, Malad, I am coming to that. The very claim of the appellant is he says that I was appointed against the first post of lecturer in English on 24/6/91. And he says that he joined on 1/7/1991. Your lordship may kindly note down these two dates. And so far as the governing body is concerned, the governing body stand is that he was appointed against the second post of lecturer in English on 24/10/1991 after facing due process of selection. And he joined on 1/11/1991. But so far as
We'll have it after vacation.
Well,
No.
well, the difficulty is
I have already mentioned in matters for last you can say last
Yes.
8 orders. Repeatedly is taking time. Repeatedly. With any plea.
No, I am taking time.
No, you are he is taking time.
You are saying-
No, I am not getting salary. You not visualize my predicament. Since 2018, I am not getting salary. I am continuing his.
you are saying kindly see one document. The appointment of the respondent number 4 that has been approved since 5/15/12/2014.
No, that is the matter.
She has been continuing in the college,
And he-
whom my learned friend is representing. My lord, she is, because of the interim order, she is not getting her salary. I am for the governing body.
Interim order says what?
My lord, interim order, that will be interim order. And his services were terminated way back in the year 2010. He is out of service. He preferred an appeal before the director in terms of the government instruction dated 27/3/83. His appeal was allowed. Then the governing body challenged the order of the director before this honorable court. This honorable court set aside that order and directed for a de novo inquiry. My lord, then the sub-collector conducted an inquiry in absence of the governing body. Then again that order was challenged before this honorable court by the governing body.
Again
Set aside, and now, my lord, this honorable court has directed that after reconstitution of the governing body in the meantime has been reconstituted. After reconstitution of the governing body, inquiry will be made. He is out of service since 2010.
and the holder of the first post, the respondent number 4, he has been continuing in service since 1991. His appointment has been approved. Your Lordship may kindly see the approval order.
Approved by the
Director. And he was getting salary for certain periods. Now, because of the interim
why
order,
salary is halted now.
well, because of the interim order passed by this Honorable Court,
Interim order says what?
but as an interim order, as an interim status quo in relation to the service of the parties, as it was on 24/10/2017, shall continue till the next date of listing.
Where is the halting of salary?
But by interpreting this order, they are not releasing the salary.
Why, brother? Whoever is continuing.
Yes,
clarify
that.
Lord, since for the same post, 2% salary, my lord.
He is out of service. Who is admittedly he is out of service.
Kindly have a glance.
Are you continuing in service? Are you
No, my lord.
the attendance?
No, my lord.
No. She is continuing.
Yes, Your Worship.
Then if she is continuing, should she not be paid? Subject to outcome of the petition.
Yes.
You want to work her without anything to eat?
My lord, for a moment, kindly.
No, that I will see. Why a moment? I will see per number of minutes necessary. Point is, admittedly you are out of service.
No,
That may be wrong.
Itself the CDCI report is not completed, my lord.
No, I see.
City report is in our favor.
My documents, they have not the direction that was the.
No, please answer my question. I'll come to your papers. I will hear you fully. Are you in service?
I am not in continued
You are
service.
not in service. She is in service. He or she? She is in service.
She is.
Do you dispute that she is in service?
Yes.
May be wrong. Her service may be wrong.
Yes.
Dispute that she is service.
Many times they have saying that there is not any salary getting.
You are not,
There is not at all getting salary because of this post is not.
No. She was getting her salary.
How you are?
Now it has been stopped.
You are admittedly you are out of service.
No, appeal is pending before your lordship.
Litigation has to take place. She has been working. She cannot be asked to work without getting the salary because Article 23 of the Constitution enacts doctrine against begar. Nobody can be asked to work without salary. The state of Gujarat versus High Court of Gujarat, 96 or 97 Supreme Court, where prisoners were asked to be paid minimum wage.
Yes.
She is not a prisoner after all. If we are liable to pay to the prisoners for extracting work from them, let us pay her first. That is subject to outcome of the petition. We are not deciding the petition on that. No?
That government will.
But how can a lady hold her body and soul together without anything being paid to her? It is exploit that contrary to CEDAW, International Convention on all forms of discrimination.
This post is itself challenge. For a moment, I draw your attention.
Of this quote by daughter dated so and so had said as that. First, when the petitioner or appellant, what you are called?
Appellant. This is an appeal.
On being asked, learned counsel for the appellant in all fairness submits that his client is presently not in service. First now. He also admits that the respondent number, OP number 4, is in service. First now. However, he clarifies that all this should not be taken as admission on merits of the main matter. First. Next paragraph. When asked, learned ASC is not in a position to answer as to why the salary for emoluments are not paid. OP number 4. OP number 3. OP number 4. From whom services are being extracted. Next slide. First, learned ASC submits that the officers in their own wisdom have construed the status quo order as not permitting them to pay the salary for a volume. This may not be correct. Next paragraph.
That is since September 2019.
Whichever it is.
For earlier periods, you
Anyway, now arrears we will not say. Now let's
Yes,
go on paying the previous immediate.
Yes.
The apex court in state of Gujarat versus Hon'Ble High Court of Gujarat, AR 1997 SC. Can anybody tell?
That is AR 1998 Supreme Court.
98 Supreme Court
3164.
3164 has observed that no labor or service can be extracted without paying the wages. Even in respect of serving prisoners, sentence serving prisoners.
Yes.
In as much as the doctrine against beggar, B-E-G-A-R, not beggar. Last time somebody typed it as beggar. Yes, beggar. Is enacted Article 23 of the Constitution of India. First one. Next one. In the above circumstances, it is who is to be directed?
Government.
OP number?
OP number.
Director.
One and two.
OP numbers 1 and 2 are directed to pay the current salary of OP number 4 with the effect from 1/5/2025. First, the claim for arrears would be adjudged when the main matter is taken up for consideration in October 2020. Yes. The meanwhile, this order to be complied with, failing which the defense of OP number 1 and 2 should be struck off.
Item 49.
49, may I please, madam?
Yes.
49, may I please, madam?
Yes.
Petitioners file applications for premature closure of the term deposit account that is denied by the
Closure of
term deposit amount. Says
term deposit amount.
2,50,000 rupees. 50,000 per each.
To prematurely receive that receipt back before the expiry of the maturity.
My account is 50,000 each in five account number, 2,50,000 rupees. As per my application shall not be considered by the authority. That's why file
Rules provide for preliminary closure.
And also, as per the notification,
the notification is that in Gazette
as per the notification, my lord, of 2023, where a deposit in a 5 years account is withdrawn prematurely, after 4 years from the date of opening of account, interest shall be payable at rate applicable to post office savings account.
Post office SP account.
But my lord, thereafter there's an amendment, my lord. Based on that amendment,
amendment petition. That is in today comes the amendment petition. When they are denied my applications, not consider my application, then file an amendment petition. In the office order and the Gazette notification, both are contradictory. Office order, totally restriction. Before 4 years, we have not received this amount.
It will not be cashed before
4 years. Before 4 years. In 5 years term deposit account, before 4 years, we have not received any amount. But in Gazette notification, after 4 years, we have received this amount. That is this, some extent is that the differential lordship. That's why bona fide and sympathetically we have give the penalty or interest to the authority to receive my amount, because the petitioner marriage was solemnized in this within 1 month, and if the father is the heart patient, your lordship.
You last month also you said within 1 month marriage is going to be celebrated.
That is extended after vacation, your lordship.
That's why the most financial problem is there. That's why my amount is there.
As per the office order, my lords, after this is an amendment, your notification. It has been categorically said that 5 years term deposit account cannot be prematurely closed till completion of 4 years from the date of deposit. In case of premature closure of 5 years TD account after 4 years, interest shall be payable at the interest rate applicable to the post office saving account scheme.
Means what?
Means, my lord,
You will not pay only.
my lords, it can be.
It can be paid. Now I want to the correct answer. I do not. I am asking you now. Whether premature closure of the fixed deposit is a recurring deposit. Periodically, we will go on making the payment.
Fixed deposit.
Fixed deposit.
50,000 for
50,000,
50,000 one account, 5 account are 2,50,000 fixed deposit.
5 accounts,
5 accounts.
5 separate accounts.
My lord.
Not cheap.
My lord, may I assist my associate Mr. Panda? Today's matter listed for amendment of the writ petition. In fact, we have filed application, writ petition seeking direction to the authority to consider our prayer. In the counter affidavit, they have considered and rejected our prayer, saying that the fixed deposit cannot be withdrawn for 5 years. Our amendment petition may be allowed so that their rejection order validity can be adjudicated by this report.
Now, where is the objection to the amendment application? You are not filed any.
My lords, I have an instruction to file an objection to this item.
Correct, but you have not filed one. They cannot wait for the marriage.
My lords,
Suppose if the marriage is broken down, who will bring the groom? You will. Are you married or not? Yes.
This subsequent event brought to the notice of the court by your amendment. That may be allowed.
We will note your submission. We will note that you have not filed any objection to the amendment application also. But question, the marriage of the daughter is going to be celebrated. And you want to hold the rule. What you should show the rule book to the groom.
Rule is only for 6 months, my lord. They have misinterpreted in the guideline. Rule prescribed absolute restriction for 6 months. After 6 months, they are making some modalities payment of interest.
Yeah.
Absolute restriction up to 6 months. They are misguided and issued direction that it cannot be after 4 years.
2 years.
That is wrong.
That is wrong. 6 months restriction is actually rule prescribed.
6 months, embargo is absolute. Once you put money in the deposit, for 6 months, you cannot say anything.
Anything, my lord.
After 6 months.
So far, I did not get some actual agreed interest. There should be a relaxation on the part of payment of interest.
That's fine. He is agreeable with that. You appear for whom?
My lord and all senior, my lord.
Your senior.
I am my associate.
My lords, the scheme, my lords, they are different for different years, my lord. If it is for 1 year, 2 years, and 5 years. This account was for 5 years. And this 5 years account, as per the rules, my lord, it cannot be prematurely closed till the completion of actually 4 years. So, my lord.
That is what your order says.
That is my lords.
Your order says.
My lords.
The notification says what? Where are you?
My lord.
What is the act which is the
Any notifications, my lord.
Any act is there?
My lord, page 33 of their counter affidavit, lords.
33.
Yes,
33.
They are counter affidavit, lords. Page 33.
No, not counter affidavit. Affidavit, they will say anything. Where is the gazette notification?
My lords. D, your lordship. Rule D.
D.
D. Where a deposit.
File the original one to the court.
My lord, that clause A is the requirement.
1 second. Where a deposit of a 5-year amount is withdrawn prematurely after 4 years from the date of opening of account, interest shall be payable at the rate applicable to post office savings account. Read, see how section rule is structured.
Rule A is complete by up to 6 months.
BC is the
permits withdrawal.
withdrawal.
The only thing is you have to read Wren and Martin and then you should interpret English.
My lord, that has been, thereafter it has been amended, my lord.
Now it is amended.
That is the amended. That is the amended rule, your lordship.
To the effect?
2023, your lordship. That is the amendment rule.
Amendment only I am reading.
The amendment rule.
See,
Rules only making some variation in payment of interest. B, C, D clause. Clause A is the restriction clause.
what to do? You are disturbing, na? Where a deposit in a 5-year account is withdrawn, comma. So 5-year deposit can be withdrawn. Number one. When? What would happen? Prematurely. Prematurely permissible. After 4 years. If it is after 4 years, then the interest would be like this. If it is before 4 years, where is the bar? Bar is about interest. That's all. It does not say no fixed deposit shall be permitted to be withdrawn before the expiry of the 4 years. There is no such text.
I will kindly have a glass of page 45.
45 of your affidavit.
No. Affidavit to process.
Your affidavit. There's 45 of affidavit.
No, man. It's a consolidated affidavit.
Consolidated. Read. Slowly read. Don't get frightened. This is one view I am telling. You may be wrong, right also.
My lord said, time deposit, 5 years time deposit account cannot be prematurely closed.
When it was?
Till, my lords?
When it was?
Office of 14/11/2023.
14/11? 2023. Now read that rule. This is the 7th, 11, 20. This is notification rule. That is only order.
That is a circular issued by the authority.
That order is issued by the
rule. That circular is
Department of Post Financial Service Division.
Now who is he? But rule says like this. You will permit them. You give an invitation card, marriage invitation card to him also.
My lord, the subject is circulation of amendments in Senior Citizen Savings Scheme 2023, National Saving Time Deposit Scheme 2019, and Public Provident Fund Scheme 2019. Based on that, this amendment, this rules has been framed. My lord, this rule says 5 years TD account cannot be prematurely closed till completion of 4 years from the date of deposit.
But rule is something else.
That has been, my lord.
That is interpretation. That interpretation does not stand to the rules of grammar.
My lord's rule, page 43, that is rule 8, that has been amendment at page 44.
Correct.
Where a deposit in a 5 years account is withdrawn from after 4 years from the date of opening of account, interest shall be payable. My lords.
That means even before 4 years, he can withdraw his money. Maybe that he will not get the interest. You can't say withdrawal is completely barred. No, it's not that way. Right now. The short grievance of the petitioner is as to he or she not being permitted to close her fixed deposits in a premature way. First, learned counsel for the petitioner, drawing attention of the court to amended Rule 8D of National Savings Time Deposit Scheme 2019, instead of rule, make it paragraph. Amended paragraph 8D of the National Savings Time Deposit Scheme 2019, as published by notification dated 7/11/2023, submits that premature encashment of the fixed deposit is not completely embargoed, and therefore the premature encashment should be permitted by the OPs. First off, he also highlights the necessity for premature encashment of the fixed deposit. First off, Hindu law recognizes three circumstances as the legal necessities, namely आपातकाले, व्यावहारिके and kutumbarthe. First, the Privy Council has held that marriage of a daughter, whether son or daughter,
The petition is the petitioner.
marriage is kutumbarthe. Can you cite that decision? Where they said this very old decision of Privy Council. These three concepts are treated in, I think it is one name I remember, the other name I do not remember. Masumat Babo. BOOE, something like that. Take out that judgment. Hanuman Prasad, Hanuman Pershwad versus Masumat Babo. 1870s or 80s judgment, I do not know. The professor used to tell me. Can anybody take out that judgment? Hanuman Pershwad. Hanuman Prasad, yes, not Prasad, Pershwad, I remember in Hindus Hindula by Mullah, that judgment is referred. Hanuman, Hanooman. Right now? Correct. Hanuman Prasad Pandey versus Masumat Babo. Correct. This is of which year? Which year, brother? Huh?
We are searching.
Show that same paragraph. Moore's Indian appeal is there. 6 MIA 393. There is a Moore's Indian appeal. Others I'm telling you, Moore's Indian appeals are 3 pages, 4 pages judgments. Maximum pages is 6 pages, which I read. The law is enunciated in such a way, simply enjoyable. If you read Moore's Indian appeals, they are called MIA, Moore's Indian appeals. It is like sipping red wine and it is drizzling on the Friday evening. So beautiful. Excellent. Such books you should read. Short, they will not waste papers and pen at all, like us. Unlike us. At least unlike me. They like wonder. Okay? Okay. Next paragraph. Learned panel counsel appearing for
opposite parties.
OP submits that the text of said paragraph does not permit premature encashment of 5-year deposit in any circumstance. 7. He also draws attention of the court to the order dated
14/11/2023.
14/11/2023, which is structured on the basis of amended provision of the paragraph, and therefore he seeks a dismissal of the petition. Next paragraph. Having heard learned counsel for the parties and having perused the petition papers, this court is inclined to grant themselves in the matter, inasmuch as petitioner is organizing his marriage ceremony in the before long. He needs money for that purpose. First off, when there is a need, extreme need, the holder of the deposit cannot say that he would not return the money to the depositor, come what may, inasmuch as ours is a welfare, constitutionally ordained welfare state, which has to recognize the hardship of the people, litigants. First one. Next paragraph. Learned counsel for the petitioner is more than justified in contending that the text of amended paragraph 8D permits premature withdrawal of the deposit. First, the said paragraph has the following text. 8D. First, the contention of counsel for the OPs that there is absolute bar is difficult to find from the text of the said paragraph. First, ordinarily, absolute bar of the kind argued at the bar, argued by the OP counsel, would have gained acceptance had the rule started with, in no circumstance, premature encashment of the deposit shall be permitted. However, that is not the case. First, maybe that the depositor is not entitled to any interest. If premature encashment is before the expiry of the 4 years. First, any construction of the rule in variance would do injustice not only to the language but also to those who seek nectar under the state. First, in the above circumstances, petition is allowed. Impugned order is
5/8/2025. Letter number 12 of 2025. Letter number 12 of 2025.
Letter number 12 of 2025.
Dated 5/8/2025.
Is quashed. First, a writ of mandamus issues to which OP?
OP number 3 years.
OP numbers 234. To permit the petitioner to encash the deposit immediately. First, however, no opinion is expressed as to whether on such premature encashment, any interest is payable on the monies in deposit. Okay.
Item 50. Lord, I am for the petitioner. Your lordship has disposed of the writ petition. Another IA has been filed at the instance of my learned senior for recalling that order and impletion of party below.
Recalling that order.
In fact, he is not arrayed as party in the writ petition. It knows necessity law because that order is no way affected to.
What is that order?
That order.
Your lordship may call it after vacation.
No, let me see.
Why I am saying, my lord? No, that your lordship may look at. Why I am saying there are some certain developments in the matter because the matter was pending in the other courts where both of us were in war, your lordship. So some orders have been passed. Awaiting that, I may not insist. So, and in any case, he was saying that he will take time for filing an objection if necessary on this. Your lordship may call it in third week of January. Third week of October.
Third week of. At the request of both the sides.
Item 51.
Yes, my lord. May I please, your lordship?
Yes.
Lordship, last order, your lordship, please to appoint commissioner for the disputed road. Commissioner, your lordship, please to appoint it also. And the commissioner also visited the spot. They are disputed.
Report is prepared now.
No, a little bit time is required to summarize the report.
Soon after the reopening of the program.
Item 52.
Yes.
My lords, item 52, the opposite party number 4 is the answering party, my lords. By order dated 1/5/2025, he was added as party and there was an order for issuance of notice. The office note shows that he has not received the notice because there is some mistake in the address of the opposite party number 4.
What steps to be taken in respect of
In the last order, your last date, my lord, you are also directed to get instruction from the officers. They have not paid their genuine dues for last 3-4 years. The petitioners are the self-employed persons and they are chartered accountants. They have filed Annexure 1. Your lordship may kindly see filed Annexure 1. The Tahsildar engaged them to collect, to prepare documents required during filing of environmental clearance. So, and in the last paragraph, your lordship may kindly see.
No, there is an order to implead.
Implead, I have already impleaded and notice.
But the notice has not gone.
Notice has gone. Then a wrong address is given.
Wrong address is given. You find out the correct address and furnish.
The officers are under them, my lord. They can take instruction. I have told them. They said that we have not impleaded. I said that actually they are impleaded by order dated 1/5/2025.
Yeah.
I'll get the instruction on. Even if this will be taking time, my lord.
Nothing.
In the meanwhile, 2 years have already gone.
Nothing will happen.
They have to pay. They are not. They have collected money.
You appear for the added party.
My lord.
Learned AGM Behra appears for
Opposite party number 4.
copy number 4 who is freshly added and seek some time to come out with the instructions. First of all in the second week of October. Okay. We'll take up that old matter, na?
Item number 1.
Let's hold that list.
Yeah, that is.
In this case, they have collected money from the highest bidders to pay me, but they are not paying me.
That's what.
Your lordship will take up with item number 1, my lord.
Yes.
My lords, in fact,
It's argued already. They have to defend that order. Yeah.
Lord, here,
Yes.
your lordship kindly see the order dated 8/2/2002. This is matter relates to the construction of a shelter, the Cyclone shelter home.
Yes, sir.
Way back in 2022, it is almost like in the form of a PIL. But your lordship kindly see the here what happened. The order of status quo was directed in the order dated 8/2/2002.
Yes.
But I pray, my lord, that if your lordship will direct the state to ascertain the present status, whether they have already constructed or the construction has been stayed or not, because the time is around more than 2 decades have passed in the meantime.
We'll the officer obeyed the order in the absence of order being shown. There is a presumption.
My lord.
Both orders are obeyed. There is such an article in the Constitution, in our Constitution,
My lord.
that called full faith doctrine, which you have borrowed from American Constitution. When Dr. B.N. Rao, Venegal Nursing Rao, constitutional law advisor, met the Felix Frankfurter, US Supreme Court judge, he said, full faith doctrine in your Constitution. Accordingly, 62 or 163, there is one such article, not 162, 262. Take the Constitution. You get Constitution. Can anybody cite full faith doctrine article?
262, my lord.
Maybe I do not exactly remember.
I'm verifying, my lord.
College days. Yes.
I have got the copy of the Constitution.
Read. Full faith doctrine. 261. Full faith shall be given throughout the territory of India to public acts, records, and judicial proceedings of the Union and of every state.
Exactly, ma'am. The full faith and credit should be given throughout the territory of India and public acts, records, and judicial proceeding of the Union and every state.
Therefore, we will assume that they have the order, unless you show the contrary. I need not ascertain from them.
No.
The order itself.
No. I'm interested to comply this order, and I believe that this should be true. I don't want to prove anything contrary to it, rather because if it is accepted, it is helpful to the petitioners. In fact, my lord, I became very happy that your lordship called me. In the matter, virtually, I don't have anything, but still I was given to understand that your lordship asked the petitioner to come and this thing, and I just received half an hour back the papers.
Sir, Apex Court has requested us not to keep any matter which is long pending. There is more than 20-year-old matter.
My lord, if your lordship will not take it otherwise, after about 4 decades, I find an order of this type which your lordship has passed order today. We never received any paper. It is 40 years back, Justice Dingaraj Ratha was there. He passed an order which was necessary, and it was directed to communicate to both the council, and it was communicated in our house. And thereafter 40 years, we have not seen that thing.
We should always.
Yes, my lord. The whole point is that your lordship should accommodate, because for long back there is no much of study, research, and this thing in our High Court is unfortunate to say. But the whole point is that your lordship should not wipe us out that to be ignorant and to proceed faster.
I will only say whatever. Therefore, I said I had read that full faith doctrine.
My lord. The more and more your lordship asks us to read, the more and more the bar will go deep into the matter, and they will read and to assist your lordship.
And they will antagonize me also. There is one shloka. I do not know which scripture, I do not know. It may be in Manusmriti itself. It says, Na chora chodyam, na bhratru bhajyam. Still it is longer. The knowledge is something which no thief can thive.
Correct, Manu.
Chora chodyam.
Manu.
He cannot thive it. Na bhratru bhajyam. Brother. No brother can seek partition in that. And next is, even if you partition, the other property gets diminished. Diminution of shares. But diminution does not happen.
If your lordship will allow me to say,
more or less my wife believes in that. Instead of Lakshmi, she has kept the Saraswati, and she used to take to her children that knowledge nobody can take away from you. Nobody can keep theft. More or less like this.
That's true.
And everybody, I mean, some of the people, they say, everybody keeps Lakshmi. How do you keep Saraswati in your house? I mean, a statue, a small statue of Saraswati there while entering to my house. And it was at her instance, not my instance. So that's correct. Your Lordship said that knowledge cannot be stealed. But the whole point is that unless it is cultivated, it will not grow.
That's true.
The knowledge, unless it's cultivated, and cultivation of knowledge, with all respect, without throwing aspersion to anyone, the cultivation of knowledge, so far this Honorable Court is concerned, it has been vanished since long, 92, 93. I will not say so. Let us
there are many people who are interested.
Yes. Everybody will be interested, my lord. The whole point is that at that time nobody was saying that no one is interested. The whole point is that I was there, I was hearing in a case, a learned friend was submitting a point, which your Lordship, it was, I think, the second day or third day of your Lordship, while sitting with Justice K.P. Kushtaram K.R. Mahapatra, your Lordship quoted a judgment along with the paragraph of 60s, that this is the judgment which has been, it goes against you. Paragraph such and such goes against your submission. Then still he was pursuing. Then your Lordship said that what I say, it's a finding is against you. Please go through it and come if it is wrong or right. But without going through it, when I say that is a judgment. So the whole point is that type of threshing out the cases, we have long forgotten. So once Justice Mr. Ramaswamy had come to a particular court, I am not naming them because it will take to be offensive. He argued for 2 days. Justice Ramaswamy, a case of Mr. Vijayanand Patnaik in old court number 1. And he argued 2 days and not a single point was noted down by the bench. And the Ramaswamy said, because I was appearing with him because of this different circumstance. Then she said that I have been arguing for 2 days, referred a lot of judgment, and the Honorable Court has not done. I don't find that the Honorable Court has noted down a single point or decisions. And then one of the judges said, who went to the apex court, that we may not have noted down, but God has given us the memory. And more than half of the lawyers laughed it. So the whole point is that what somebody is saying, he should practice it. Because previously they were saying, they go and read and come. That is a judgment. What is the letter? First question is that on what point and what is the letter judgment on this point? So there was no sound. And I am told that your Lordship is saying, whoever is creating sound, then please. Your Lordship said very mildly, but we had a judge, Justice Patnaik, that whoever will create sound, I will make him stand up on the bench. There was no sound at that time. But unfortunately, your Lordship might be remembering Justice Nanavati, G.T. Nanavati. He had come here as a Chief Justice in sometime, I think, in 90s. After 5-6 months, he was very friendly with Justice Ahmadi, who was the Chief Justice of India. And he found us to be very, dull bar, and he requested and he went away to your Lordship state. From here to he got transferred, managed a transfer through Justice Ahmadi and went to Karnataka. So the whole point is that it happens, my lord. But we are very happy that, in fact, that last 20 years I have not seen the client. It's almost a PIL. I see that I have filed as an intervener. Now again I'm going through the order sheet that I wanted to file on behalf of the petitioners. Nobody is in touch with me. But since the manner your Lordship requested that you come, I said I am not appearing. It should be ordinarily, in last 20 years, everybody dismisses for non-prosecution. So when I said that, then again
non-prosecution, because for 20 years, the litigant will be there.
No. Whatever it may be to be threshed out, we have to assist to your Lordship. That's it. I said that I felt happy. I could have said that I'm...
Thank you for your compliment.
It's not a compliment, my lord. It's a appreciation in appreciation in true sense. It's nothing a flattery.
I am obliged. I'm obliged.
Because I'm otherwise known. I'm not a flatterer. I'm rather known more negatively.
No, sir. I took your words as compliment to me. Yes.
So that's why I thought that your lordship must be quoting also constitution. That is why I kept the constitution right on my right side of my table. I may not have, because we have not referred all those constitutions, provision of constitutions. There is no churning. This whole point is there is no churning. The more and more your lordship asks, the more and more the law will read. Here, this is basically regarding the construction of a shelter home, my lord. Yes. And where the proceeding, the construction is going on at the instance of the contractor, contrary to the suggestion given by the state agency in their inquiry report. What I was going through the intervention petition, that is 1509.
Yeah.
It was filed. I had appeared in that case, but later on probably there is an order. I undertook to appear for the petitioners, though I have filed appear for the intervention. That is miscase 1509 of 2002.
1509.
My lord.
150.
They are constructing a place where they say that it's not helpful for the villagers. It should be constructed there, and where there were reports of the state agency, the Tahsildar. Your lordship, can you see that petition?
Yeah.
Pleadings made in that petition.
Sir.
Paragraph 4.
Page number?
Paragraph 4, page 4, my lord, of the miscase 1509.
1509. No, 1509 has been dismissed as having become infructuous on the submission.
Maybe.
So we are arguing now OGC 16939 of 2001.
Yes, that intervention is in support of the petitioner. There is nothing contrary to the prayer made by the petitioner. They are supporting interveners.
To support the intervener.
That petition is supporting interveners, my lord, supporting to the petitioners.
Supporting the petitioner. Your client supports the petitioners.
My lord.
Oh.
But there is an order on 8/2/2002. I undertook to appear on behalf of the petitioner.
8/2/2002. Advocate submitted that he will appear on behalf of the petitioner and undertakes to file the wakalat in the court. Mohanty and the additional government advocate appearing. In 2002 also Mohanty was there, additional government advocate. Another Mohanty.
Another Mohanty.
This bar gallows with Mohanty.
Hello.
What here on according to the
Because in that order, 8/2002, since there is an earlier order of status quo, let the order of status quo shall continue till 13/2/2002. But thereafter, whether the construction is done or not, the state can say.
Whether the status quo was continued thereafter, Mr. G.
My lord, as the order sheet says, my lord, on 10/1/2002,
32/2002.
my lord,
Handwritten also.
status quo was issued for 2 weeks. Thereafter, my lord,
Shall continue till that day.
my lord,
That is 16/2/2002.
16/2/2002, my lord. 16/2.
Thereafter, no interim order. But the counsel for the petition.
And there is another matter, 27/2 also interim order is extended.
also interim order was there.
Special messenger.
And 22/4/2002, the opposite party number 3 is restrained from making any construction until further orders. The opposite party number 3, if he has appeared through law, he can say so, my lord. He is the contractor, I think.
Contractor. No, vacated. This 17/5/2002, sir. Order.
My lord.
The interim order dated 10/1/2002 directing status quo relating to construction of Cyclone shelter is vacated.
My lord.
Clearly. that in the event of the writ petition succeeds, appropriate orders will be passed to protect the interest of the petitioners at the cost of the Orissa State Disaster Management Authority. Put up the writ petition on 1960. Which is that writ petition? This is by division bench.
Division bench. At that time, writ petitions were taken up by division bench, all petitions.
Is it? Okay, thereafter it has come. No, that was writ petition.
My lord.
This is also.
Huh?
This is also a writ
This
petition.
is also writ petition.
Writ petition.
Is it?
Yes.
It's in writ jurisdiction.
Writ jurisdiction. It was
Earlier nomenclature.
Yes.
earlier, it was before the division bench.
Now it is before. Therefore, interim order is vacated.
Vacated, man.
On 17.5.
No, what learned counsel is saying is whether after the vacating of the interim order,
Yes.
put up construction structures is the question. Suppose if you have put up structures for cyclone protection
Exactly, my lord.
structures, then nothing will survive his submission.
Yes.
There need not be any order at all.
Can I pray, my lord? Lordship may call this matter after holidays. I shall
No.
go with thee. Today.
At least can you speak to your deputy commissioner and tell it over phone?
It is little away from here.
All right, away. But the phone is never away. Even if you speak to Bill Clinton, it will be with phone only.
Let me try, my lord.
I'll have it tomorrow then.
Tomorrow, my lord.
Tomorrow.
Yes.
In the meanwhile, you collect information.
Day after tomorrow, my lord.
All right, day after tomorrow.
Yes.
We'll have that. Yes, sir.
Obliged.
Sir, day after
Obliged.
tomorrow.
Man.
Yes. Reluctantly, this more than 2-year-old matter is adjourned to
20-year-old man.
2 decades, more than 2 decades old matter is adjourned. Adjourned to good time, I think. At the request of the AGA. Yes, sir. Just ascertain whether cyclone protection
Center has been completed or not?
If
Yes.
it's completed,
Then
nothing
but nothing remains, my
As
lord.
rightly learned counsel pointed out, nothing remains thereof. Yes.
Item 53.
Obliged.
Yes.
53, your lordships, the whole thing emanates, I think, starts today from the judgment of a coordinate bench, which your lordships will find at page 75, annexure 9.
Can you make the statement?
Lordships?
Can you make brief statement? What is the case?
Lordships, your lordships, these are persons, the petitioners are persons who are working at the block level under the OPEPA, which is a body created to basically see the primary education in state of Odisha. It is under the Department of State of Odisha Education and Child Welfare Department, your lordships. And when the OPEPA was formed by the state of Odisha, there was a condition that anybody you employ has to have a service condition either equivalent to the central government or the state government, because it's funded both by the central government and state
A particular
government.
ratio.
Yes. So therefore, you will have to give them a condition of service which is either equal to the state government or the central government. When it came to the post of accountant, in the state level and the district level, it was almost that of the government servants, the civil post holders. But when it came to the block level, they did not do so, and they only started with a very small amount of 5,200 consolidated payment. Your lordships, we filed an writ application where the order came in our favor, that looking at all these aspects. And however, in that order, the court said that you may, as because there was a submission from the opposite side, that we need to have a word with the central government and the state government.
Yeah.
They said you put up that recommendation and you do it. So, but instead of doing that,
Who appears for the
Your lordship, senior counsel Mr. P.K. Mohanty appears. He's on accommodation, your lordship, today. I pray for an adjournment, your lordship.
Can you have it after it?
lordships, first week after vacation, if you lordships.
Week also is vacation.
I know. That's why I proposed
Second week of-
13th, the week commenced, the week commencing from 13th.
At the request of
Last time
Inform
also.
the learned senior advocate.
Lordship,
Whenever
we had
the tradition is,
Yes.
whenever senior advocates are appearing, unless you do not know for whom they are appearing, yes, you should indicate we may seek adjournment. Yes.
No, in this case, he did not know because I'm appearing today for the first time. But last time also they had taken time, so I hope they were.
On 13th again, don't.
No, Your Lordship, this is only.
Obliged.
15, 30, 51, 41 matters are already questioned. Then 15. Huh? How many matters are there? 2 matters. We'll have it on 15. Yes.
Item 54.
Before my lords, my learned sister, Mrs. Manti was here. She is on her legs. I appear for the opposite party number 1 and 2. I'm entering appearance today. What I humbly pray is your lordship may call it after vacation.
Learned panel counsel Mr. Patnaik appears for
OP number 1 and 2.
1 and 2. Call in the 3rd week of October at his instance.
Yes, ma'am.
Item 55.
55, Mary Lordship, I'm from behalf of Janaki Mahapatra. Order is in hospitality. After vacation will come.
The 1st week of on request of. Yes.
Item 56.
May I please, Your Lordship?
Yes.
My lord, may I pray one thing?
Yes.
My lord, this item number 56. Your Lordship may call this matter tomorrow along with WPC number 26088 of 2025.
On 15, we'll call this, both matters. Tomorrow whole week.
Transfer matter, interim order is operating against me. It can be disposed of within 5 minutes.
No, but the many matters.
Can it be on
Immediately after vacation.
day after tomorrow, my
On
lord?
7th.
Day after tomorrow, Your Lordship may keep
No,
it.
we have posted many matters. In fact, in the last week, when the vacation begins, that last week, in any court, in many courts in the country, I do not know any court.
Yes.
Courts I have attended as a guest.
Nobody used to take hearing matter.
Pending matters, nobody.
Yes.
Because
Well,
only
that is the
after
practice here also.
vacation.
That is the practice here also.
We
Well,
will have this matter on 9th of, how many matters are posted on?
9th, Your Lordship may keep it.
9th.
9th.
14 minutes. 14 minutes. Yes, put this also.
It can be disposed of within 5 minutes.
But interim order may continue. There is
We
an
want to continue till 9th.
It may come along with
WP number.
WPC number 26088 of 2023.
Yeah.
Item 57.
57 also carries the last order. 10th September order. Also directed to call the report from the seal cover report, medical report.
Examination. What was the matter? Why I directed the medical examination?
May I please, my lord?
Yeah.
My lord, there was an inadvertent error committed by my part in the IA. In the writ petition, the deformity of the petitioner was rightly described, but in the IA there was a mistake committed by me. Your Lordship had directed to ascertain whatever was avoided in the writ petition, whether that is correct or not. That's why Your Lordship had directed to ascertain the degree of disability.
The petition they have stated as a physically disabled person.
Physically disabled.
And the interim application they have stated polio patient.
Right.
And you also pass the interim order basing on that polio. He is a polio patient.
I have
Therefore,
Yeah. What is the subject matter?
My lord, the petitioner was placed under suspension, Your Lordship, because the opposite party, the principal of the college, had deducted from his salary some amount. When he sought for an explanation, being enraged, the principal put him under suspension. That was the prayer before Your Lordship that it is not in accordance with rules, and the suspension should have been confirmed by the director. And in 2 months' time, it has not been confirmed. Therefore, the humble prayer was that it should be deemed to have been
Revoked.
well.
Who appears for the opposing party?
I am for the institution.
Whether a suspension requires any confirmation under the rules?
There are the two provisions, my lord.
Yes.
As per Rule 21 of the 74 rules says, my lord, the governing body or the managing committee may place an employee under suspension on contemplation of proceeding and requires approval from the director within 1 month.
Within 1 month?
1 month.
Suppose within 1 month approval is not granted.
Not granted.
What will?
Suspension will invalid.
Then in this case it has happened.
Yes.
Is there approval granted?
That instruction this last occasion I appeared. Counter has not been filed. Only he has filed an IA. That IA has come last occasion also directed to.
Who should grant the approval?
Director.
Whether director has granted.
My lord,
has he granted approval?
I have also not received instruction. I have sought instruction 13th September, my lord.
And here the director is not a made party.
It's the opposite party number one.
The percentage of disability 55%.
Yes.
Yes, that
Therefore, we can't say that.
now we'll also examine the validity of the suspension order.
What is the validity of suspension? Where is the confirmation?
My lord,
Tell that confirmation. 1 minute cases.
Yes, that authority has not been made
my
party.
lord's director is not a
Yes,
party.
that authority has not been made party.
Whether now the other state is a party.
My lord,
State is the above. He is above director and he is the highest authority. It is highest authority.
my lords, I have not received any specific instruction. That is, on 13th, I have sought for instruction, 2nd September.
13th September.
Yes.
Where from it should come?
Daspala.
Bhubaneswar.
Yeah.
Even if they were to crawl, they would have reached the court by now. Call this matter immediately. Yes. First off, learned AGA to state whether the suspension in question was confirmed by the competent authority in terms of Rule
21
of
of the 1974 rules. That very big rule, my lord. That
19. All your rules are long.
Recruitment and service condition rules.
Write down and give that. To the extent.
the rule, my lord, the rule is
Let my friend make director as a party. It will be better.
My lord, it's the direct.
no under the rule, my lord. Director is the prescribed authority to approve the suspension. And here, my lord.
So you should say whether approval is granted.
No, that instruction I don't have.
No, you should have had the instruction from your client.
Yes.
You suspended him. You suspended him.
Yes. Yeah, we have suspended and also wrote to the recommended director.
Where approval, unless you have secured approval, that I have
That is so. Next day I will some.
Where is the next day, brother? I will allow the petition. You can, how many days he was kept under suspension?
No, suspension order 26/4, 25.
26/4.
And no subsistence allowance is being given.
No subsistence allowance is also.
That issue is now subjudice because that is a blogger and employee. Whether the rule is applicable or not, even though the single judge has passed order, that rule is applicable. Now is under challenge or interpret.
That's all right. But management has to pay. Grant is whether the state should pay or management should pay. Where there is grants, management will not pay. But where there is no grant, management has to pay.
No, here in this manner, in the present institution, after the petitioner brought on the fold of granting it,
we will say that there is no confirmation order is produced before me. Therefore, that petition had
today come for other purpose. Let's may call it some other day. I will obtain that instruction.
Call this matter on 16 very reluctantly. Received the medical bulletin from the Chief District Medical and Public Health Officer, Maya Garu. Yeah. Registry should send the first one. The swiftest effort made by the board is appreciated. First off, registry to send a copy of this order. All those doctors who are those doctors. To all the following doctors, stroke medical officers by speed post, which would constitute their, which would gain entry to their service reports as positive credentials This 4 minutes, the 4 minutes. Yes.
Item 58.
May I please, my lord?
Yes, sir.
My lord, item 58, your lordship has been seeking for compliance of the order of this honorable court for last 5 occasions, your lordship. The compliance is not coming, your lordship. Your lordship had directed and observed that the order of the...
Mr. G, that first matter I have posted it the day after tomorrow.
Yes,
That day you get the written a letter.
I'll get that.
Yes.
I'll get that. Oh.
My lord.
Yes, sir.
My lord, in this case, the petitioner was appointed as principal, come secretary, your lordship. Why annexure 1?
Which order court wanted to?
My lord, the order at annexure. My lord, the order at annexure 7.
Annexure 7.
My lord, the page number, relevant page number is 29, your lordship.
Brother's order.
My lord. My lord, the conspectus of the case is that the petitioner was appointed as principal come secretary, and he was transferred to another college where his service is less than a year left. So he approached this honorable court, and this honorable court quashed and set aside the transfer order and directed at page number 29, your lordship, under paragraph 7, that the petitioner shall be allowed to continue in his present post till his superannuation. Your lordship, his present post was principal come secretary to the college under annexure 1, your lordship. That order, it was directed that to be complied within 10 days. Your lordship, they didn't comply that. The petitioner is not getting any salary, and the entire system has been put in limbo. Now they have transferred the financial power to the sub-collector, extreme concentration of power with the sub-collector. And the college is suffering, the petitioner is suffering, the rule is not being complied. If your lordship allows me.
Yes, sir. Why order is not complied?
My lord,
Yeah.
the order was
To continue.
having heard, let me place my
Page
lord.
number?
Paragraph 729.
Yeah.
Having heard learned and counsel for the parties and considering the submissions made and the fact that the petitioner is going to retire on attaining the age of superannuation on 30/11/2025, this court is of the view that the petitioner should be allowed to continue in the present place of posting. This court is of the view that employee should not be transferred at the fag end of his service career. In that view of the matter, while interfering with the impugned order dated 2/6/2025 under annexure 4, so far as it relates to the petitioner, this court directs that the opposite party number 1 to allow the petitioner to continue in his present place of posting till he retires on 30/11/2025 and pass an order accordingly within a period of 10 days from today. My lord, I humbly submit that the petitioner is continuing there. My instruction, your lordships directed me to obtain instruction. Lordship, I had obtained instruction on 11/9/2025. Should I place that instruction, my lord?
Just read.
My lord.
Saying this order was made on which date?
My lord, this
24/7.
No.
the petitioner, Nikunja Bihari Mahapatra, the reader in English was transferred and posted as principal come Bharuneshwar College RA by order number so and so dated 2/6/2025. In the same office order, Sri Ujjwal Kanta Das, reader in mathematics, who is senior to Nikunja Bihari Mahapatra, was appointed as principal cum secretary of Sadhu Gaureshwar College, Kanikapada. Honorable High Court in its order dated 24/7/2025, passed in WPC number 15705 of 2025, filed by Nikunja Bihari Mahapatra, directed that the opposite party number 1 to allow the petitioner to continue in his present place of posting till he retires on 30/11/2025.
Yeah.
Accordingly, the petitioner was allowed to continue at Sadhu Gaureshwar College, Kanikapada, only as reader in English till superannuation by letter number so and so dated 4/9/25 in compliance to the court's order. That there is no separate sanction post of principal in charge in non-government aided schools. Such assignment is an additional responsibility given to a teacher basing on his seniority and suitability according to along with their primary duty. It is neither a promotional post nor does it carries any additional financial benefit. That all the teachers appointed against a direct payment post in non-government aided colleges belong to common cadre and are eligible to take responsibility of principal in charge in non-government aided colleges under the purview of the higher education. The petitioner has already handed over the principal in charge to Ujjwal Kanta Das, reader mathematics on 2024.
He has already retired.
He is retired in the meantime.
Not arise also.
24/7/2025 with reference to this Honorable Court's order. Ujjwal Kanta Das retired from service on attaining superannuation at present. Sri Jitendra Kumar Das, reader in Sanskrit, Sadhu Gaureshwar College, is senior to...
From other college he has been brought.
Yes.
No.
Yes.
That's his other college.
No, my lord, it is, I don't know, my lord, that he has not written here.
Yes, he has been brought
At
on.
present, Sri Jitendra Kumar Das, reader in Sanskrit, Sadhu Gaureshwar College, so-and-so, is senior to Nikunja Bihari Mahapatra, reader in English. In these circumstances, if the assignment of principal in charge is given in favor of Nikunja Bihari Mahapatra, the natural justice, that is what the instruction they had given.
No, he was in fact, he was the principal when transferred.
My lord.
Transfer is set up.
He was principal in charge.
No.
That's all. All right, we'll assume that principal in charge. Make him principal in charge. Why you want to bring, which is that judgment? HP Lakshmi Narayana versus KFDs. There is one judgment of Karnataka High Court by Justice Sridhar Rao. You can't bring somebody on deputation when already the insider is available on that principle.
That I do not know whether Jitendra Kumar.
Do you have that? Yes.
Jitendra Kumar.
Let's look into this, Mr. G. 2001.
My lord.
AR 2000. 2001 AR Karnataka HCR 67. Have you seen that judgment?
No, I'm just finding out.
You look into that judgment and come.
I will also get that whether this man Jitendra Kumar Das was...
One paragraph reads, I remember because when I have read his judgment.
This Das was from brought over from another college.
College.
Or
because
I have the...
and he that other person has retired now.
Yes. And that man has retired. Now he is to continue there as per direction, my lord.
No, he's from other college. You are just ascertain.
No, I'll ascertain.
I'm given he's from other college. He's from a school. He has been transferred from a higher secondary school. My lord, if your lordship allows, I will just show the judge, because this entire issue has been adjudicated at the division bench level.
In fact, judgment can be written on either way. Because what is your right to claim principle?
That is what.
Except that you are the now senior most. That itself may give you some stead, I understand.
No, this entire issue has been adjudicated at the division bench level in a mirror image case, your lordship. And what my learned friend is saying would amount to contemptuous if your lordship kindly looks at page number 47. This what the stand my learned friend right now took has
take out those two. This is a small judgment. That judgment give the xerox of that copy to each of them. Okay, it's a very small judgment. 3 pages.
My lord, page number 47, paragraph 11. The exact matter was there before the division bench, your lordship. Whether there is this post of principal is available or not. Your lordship, the last line, this entire avowment that was right now submitted has been termed as ipse dixit by the division bench of this honorable court. In a similar case, the petitioner there was serving as principal cum secretary. He was demoted to the rank of reader, and it was considered, it was avowed by the opposite parties that there is no post of principal sanction. And the entire thing has been described as ipse dixit, and the post of principal cum secretary has been upheld, and it has also been directed that transfers to these colleges have to be sensitively done. All the issues have been dealt
very extensively by the division bench of this Hon'Ble Court. The judgment I have annexed, Your Lordship. Paragraph 10, 11, 12 covers all the, because my lord, your lordship on 9th had observed that somebody is doing the mischief. If your lordship allows, I would just submit who is doing the mischief and why. The mischief is being done by the opposite parties because they do not want the regularity in management of colleges, your lordship. Your lordship had deprecated this concept of principal IC. Your lordship had delivered the judgment. I can pass on your lordship the same judgment. That your lordship had deprecated this practice. That what is this practice of appointing principal in charges? But they do not want to appoint principal from secretaries, in spite of the order of this Hon'Ble Court, that you cannot go on your lordship's order. They do not want to post principals. They want to put principal ICs, and your lordship, to make the matters worse, by an order, they have transferred the DDO power to the collector. Your lordship may kindly recall, in another petition I have filed, they have demolished all the governing bodies. So now, your lordship, the sub-collector is going to run the colleges as the president governing body, as the DDO. The entire subdivision, the collector, sub-collector will do. That is what they are trying to do. They are trying to nullify the order of the division bench.
Let me get instructions for that. Things will be, let it come day after tomorrow or start.
No, what do you think they will come?
My lord, you not.
Okay. Mr. Chief, but then he wants to ascertain whether the person now placed in charge of the office of the principal is from the very same institution or from the other institution.
My lord, you kindly see it there.
Wants to giving some reason.
The order time to
Get also some more instructions from them.
Counsel for the petitioner incrementally asserts that which is not permissible.
Who came by transfer order dated 24th June 2025. 26 June 2020.
Who came to the position by virtue of order dated
26 June 2020.
6 2025. First, for this matter, the review. Yes.
Item 59.
Thank you, sir. 59. There's a matter regarding publication of the result pursuant to Annexure 1. There is a writ application is for publication of the result. Now we have already taken steps for publication of the result. It will take some time. But it says that matter will be taken up after vacation. In the meantime, it possible to publish the result.
Why delay in publication of the result?
Delay is technical questions.
No, what should happen to the next level of education? What should happen to the prosecuting in the higher level of education?
No, it is the appointment to the service. The selection to the service.
Selection for
teacher.
Leave training.
I am for the petitioner, my lord.
No.
I am for the petitioner's, my lord. My lord, the brief is.
I am for the petitioner for the first writ application, lordships. I think my
In respect of first case, I am making my submission. In respect of the first case.
That the steps are taken to.
Steps have already process is on. Now result will be declared within 15 or 20 days.
20 days. Why?
Because there is a large number of candidates.
How many?
More than large number.
Let's see.
20, 30,000 candidates.
20,000?
No. Total post.
Petitioners are limited. After this, only 90 candidates applied before lordship.
But result belongs to all. Brother, do it within 2 weeks.
Yes, you are doing it.
Right.
Yes.
May I please, your lordship?
14th or 15th or 16th. 16.
First, the undertaking of counsel appearing for
Staff Selection Commission.
Staff Selection Commission that on or before the said date that should be published.
Keep it on that. There in the meantime, any day.
You have said that, and therefore we are starting that.
I say in the meantime, we are trying to do it. But,
no, you have to. Then I'll make an order.
Because several other cases are also pending.
Well, let them pend. What about the publication of the result? Fail or pass?
No, pertaining to this case, pertaining to this selection, other cases are also pending.
Very well.
Yes. So we have to take into account all those cases and publish.
The publication of results of how many people? How many people? How many candidates?
Many in the second case, I think.
No. And what is difficulty now with all the computer system available at your tip of your fingers? Why delay?
There is no delay because of the interim order. Some cases there is stay order. Some cases subject to filing of the writ application. So all these cases are there.
Staff Selection Commission shall publish the results of all the candidates, except those wherever there is interdiction by the courts.
Yes.
As on or before 16th of October. First one, come on. Filling which, whether a chairman or a director.
The chairman is there.
The chairman, who runs?
Chairman Vartan now in charge.
Now the executive of the chairman of the commission may be personally summoned for offering explanation.
No, we are not delaying. He is filing a case. There is no question of delay. Why he has filed? But other subjects were published. His case has not been published. There is no delay at all. There is no question of delay. Recently examination was over.
Where I have said delay?
No, sorry, appearance of the chairman.
If he does not have the order.
But appearance of the chairman,
that will be
that will go detrimental to our interest.
Appearance of the chairman for offering explanation as to why penal action should not be taken. Yes.
Problems.
Yeah.
In the second sub-item, let's say I have in the second sub-item,
yeah.
I have filed the intervention application. It is 14101.
They will two costs otherwise.
Brother, you said you are going to take steps for publication of the results. It is there. If I replay it, it will be there again. Number one. Kindly listen to.
Yes.
Kindly listen to.
Yes.
You said that steps will be taken for publication of the results.
Yes.
Then we agreed with that. We wanted to post it on 16, saying that you have said that publications will be done. Number one. Number two, you argued there are stay orders by various other high courts, other benches of this court. Then we said, barring those cases, publish rest of the documents.
I agree to that.
Then what is that? If it does not apply, again one more contempt and other thing. We will do it here only. We court orders.
You also pass that order without this observation.
No, why? How can lawyer
that observation always go against us?
That should go against you. That is the object.
No, why against me, my lord?
Not me.
That will go to no, they will understand otherwise. They will understand it otherwise.
But the court orders.
Today morning I got the copy yesterday. Today morning I got the instruction that we are processing. We are going to publish the results shortly. That is what I am making my submission. And if personal action has to be in this case, then we will be misunderstood.
But others they will not comply.
No, they will come. Why they will not? They will come. When I say they will come positively. There is no hindrance. That is the duty. Their duty. They will do it.
But many cases I have
seen. No, at least in my case, also take it granted, there will be no such thing.
No. Last one, appearance you can.
Lordship,
that should not be reflected on your professional.
That happens in many cases. That is
Lordship.
But next time,
I assure.
If it does not happen,
that will happen.
But take it from me, I will direct arrest and detention of the concerned officers. That is the only way to comply with the order. No other way. I have seen many orders in this court. Unless somebody is put behind the bar, no work happens. No compliance is reported. But I am putting you on anyway. Now, as you said, they may mistake your advocacy. Therefore, I have made that now. That I have. But next time.
Your Lordship will not find a single case where staff assumption will not comply with Lordship's order. That I can assure.
Your Lordship.
That I can assure.
Very.
Your Lordship, connected matter is WPC 1490320.
Yeah, that should. What else is required?
Your Lordship, my writ application is 149032025. Here the challenge made to the irregularities committed in the examination, Your Lordship. Lordship.
But let them.
No, my Lordship. In my writ application, there is an order of the Lordship to not to publish the result, Lordship.
my humble submission, Your Lordship, they have committed irregularities. They have the question paper given, which was open.
No, I'm not hearing now.
No, my Lordship, if the result will publish, Your Lordship, will be affected.
That's, no, what other?
Your Lordship, 132 page, Your Lordship, kindly have a glance in my writ application.
In your application, we are not saying other results should be published. Only wherever there is no interim order. Those cases, otherwise, how he should work?
The due to irregularities committed by the examination authority, Lordship, we have been failed.
If
the result will publish, Lordship, will be affected.
How you will be affected? That will be subject to the outcome of the hearing.
Then,
now, what he says is true. One court will say publish the result. In other cases, don't publish the result.
Exactly.
Then what they should do?
No, my Lordship. No order, Your Lordship now passing the order for publication of result, Lordship. But till date, no such order is there. In all writ applications, the order is there not to publish the result, Lordship.
Publish the result. Yes, next.
Publish.
Next.
Item 60. My intervention application may be allowed in for adding maybe the party because I am the agreed party.
You want to become party there?
Yes, Lordship. In
Copy of the petition also.
Yes,
you copy.
Yes, just.
All right. You look into it. Say next.
Yes.
Call them.
Item 60? Yes. And item 60. PCC 26/8/2025.
Yeah.
I am appearing minutes the first. Last day I am appearing for the Union of India. The instructions to appearing for the opposite party number 4 minors the school minors. I pray minors 2 weeks time. I will count.
Sorted number.
In this case, I have already applied for the Kendra with the 2 and 3 and filed counter petition. Already served the copy to my lord.
What is the prayer?
Petition are the small.
He is the petitioner. I am submitting also. The prayer is.
I am submitting.
I'm asking him to be entitled to answer court's question. You have no answer to stop. No.
I am a petitioner. That is why I am.
But court wants to know.
All right. He may submit.
Stop like.
He may submit.
The petitioner wanted to admit in the Kendriya Vidyalaya, all the 25 petitioners who has already applied on the basis of admission guideline. Here they all are applied. And out of 25, 4 already selected, 2 already admitted. 2 already selected because there are interim order, 2 we are unable to give. And another 25 petitioners, those who are already applied and admitted that the KBS authority strictly following the admission guideline, he is admitted in there the arguments and also stated that no illegality committed by the KBS authority. Again, they have came to the court to give the admission, bifurcating the admission guideline to them, perhaps they will not get the chance. And their latrine number, allotted their latrine numbers. I have annexed that latrine number.
Are you going to give the seats to all these people?
No, because they have got the latrine numbers. All applied. New KV open in the campus of the ITBP. Only one section from 1 to 5 open, each section 30 standard, and advertisement made. His case that the ITB public school upgraded and taken over the KBC, which is a wrong and misleading statement before lawsuit and first admission stage. Therefore, lawsuit interim order granted 25 seats stay order, and we obey your lawsuit order. And 25 seats already stayed. But actually that is not a fact. Fact is KBS has opened as per a proposal sent by the...
Let him say no. Because you are saying that his assertion is wrong.
Absolutely. My humble sense. Yes. There is a public school inside the campus of the ITBP campus, which is central government organizations, that process are theirs. And in that public schools, the students of the staffs as well as some students of some local peoples are continuing their studies, and they are in the middle of the sessions. At this stage, KB opened a new schools in that campus with all consideration with the ITP.
But he is saying it is not our school at all.
KBS are opened as per the central government. Central government has decided 85 KP open all over India, one of the within the ITV campus district Khurda.
So it is your Kendriya Vidyalaya.
Kendriya Vidyalaya open as per the proposal given by the ITVP and the temporary accommodation provided till the completion of the permanent building land provided with the ITVP. But we are continuing KB for the sessions 25 and 26 for 1 to 6 only each section, one section for each class. And we have made the advertisement for public. There are certain priorities, as you also knows, from 1 to 5 service priorities, and that is the SC, ST and OBC priorities. And after advertisement made, all the ITV public schools parents, they have also applied, include 25 petitioners. They have all, as per the admission advertisement made by the principal KV, they have applied. We have considered their case along with others. They have, we have given letter number them, that is annexed them. Out of 25 petitioner before Lordship, 4 were selected, 2 already admitted, 2 within selected, but we are unable to give because the stay order there. Another 25, they have got their letter number along with others. If they will, their turn will come, they will get. But I forgetting the admission guideline, we cannot give the 25, 21 names to those who are in the upper.
Let us see that.
Each case, there is one case. This ITVP and KB is not autonomous. KB is independent.
Yeah.
This is the ground I have taken.
We are continuing in a school inside the campus, run by the ITVP. And our now by opening up KB has taken up school, our inspectors, our staffs, our everything. But in the middle of the year, students will go. The presents and the principal kept seeing that we will continue taking into admission into KB. That is why now in the since March to now it is September, but now they either they are giving PC or CLC to us to go elsewhere, or they are schools. No, they are not also taking under KB. Now the students and the parents are in middle of the sessions. They are no way out to go. Now, when schools, our inspectors, our staff, then they are doing just as the sessions only. That then they can only admit the new students for class 1. They are not to admit students standard 7, their guidelines also there. When a continuous school is taken up or upgraded or is taken up, then who will go? They are taking that corporation of opinions. They should take
their infrastructure is taken.
The staff and the teachers, staffs, absolutely not. That is KBS staff. Their staff, that is independent of the. That is wrong. How it's open. He is appearing to the ITV Patra. He will report himself. He is the independent body. We are the KBS is the ultimately society.
School is stopped.
They are working together. He is the ITVP authority, appearing for the ITV's Union of India and ITV. I am for the Kendriya Vidyalaya.
Right.
2 and 3.
In your discussion, he is afraid to open his mouth.
Don't say like this. I'm chatting.
That is the parents' instruction. You are also recording.
Don't say like this. False public and
That is the mistake.
I will tell you. Wait.
I'm thinking.
One
yourself.
You can't say unless whatever he is saying. You should not say that. Whatever is brief to him, he is saying. It is open to you to say. What he is saying is not true.
Not correctly. What would you say?
In the record, he is behaving as tooth or This is a student. This is not.
Statement. Now you do one thing.
He is misbehaving.
One second. Now it is 4 p.m. Both should go to the coffee house. Together. You offer coffee to him.
This
Matter on
Commencing 13th my lord, we have definitely filed matters.
you are not yet filed counter.
I have
Notice you received the notice.
Well, instruction my lord 15/9/2025. There is instruction to
These
appeal.
are all school matters.
Yes, my lord. I have only my lord. 13th I definitely filing copies of my lord.
Then we call this matter on 8th on reopening. We are calling.
Problem my lord.
What problem?
मैं तो पूजा holiday नहीं लेती मैं
Puja holiday, you are going out of the country.
home my lord, let him go.
On 10th we will have that.
Yes,
10th already.
yes,
Brother, can we have it on 10th?
yes.
Done. Now both all three should go for coffee. Yes. And whenever these three people argue, mic should be put up. Yes. All matters over now?
Sir.